Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on a 3-hour journey through Courtlandia. Apologies that we were delayed a couple of minutes. Quite honestly, nothing was really running. And then Judge McNally came in for the win at the last moment rather. So we'll start with him. And Tim, thank you for gifting a membership already. Appreciate you, sir.
KTB Carriers LLC, 266118448.
Michael Levitt, I also represent that defendant as well, Your Honor.
There's nothing on the stip form. What did you guys agree to do on this one?
We're also going to set it for a formal hearing because it involves the same issue as the other defendant. So if we could maybe do the same day, the 28th.
Yeah, what is that issue? I'm curious.
There is an issue regarding the sign off the bridge.
Okay, July 28th at 9. We'll do this one as well, okay?
I really appreciate it. Thank you, Your Honor.
Have a great day. Thanks.
You too.
Hernandez, Mike Michelle Lynn Hernandez. Come on up here, please. 24W835 456. And then I have another citation here. That is 2026 case, 26W84243. Your name? We issued a show cause on this first one. You didn't show up back in 24. Why?
I guess it just slipped my mind.
Slipped your mind. Do you have the money to pay this? It's
That's
$248.
what I was coming for today to see if I could set up some type of payment plan with you.
How do you think I'm going to react when you didn't show up here for 2 years? Now listen to me. I'll be fair with people. I expect them to be fair with us. How much do you have today?
Today I could do 50, but I get paid Friday.
Where do you work?
I work for special care OBGYN.
For who?
Special care OBGYN, it's a doctor's office,
Then
medical field.
how much can you pay per week then?
Pay $100 a week.
You get paid on Fridays?
Yes. Every
Okay.
other Friday.
I'm sorry,
Every other Friday.
pay 100 bi-weekly or 100 weekly?
Do 100 weekly.
All right. You pay 50 today, balance the rate of $100 weekly. Can we start on the 20th?
I can start this Friday, actually.
I'll make it on Monday, the 20th, okay?
Okay.
The other one, Lisa, the case that we haven't show caused her on, I'm just gonna have her pay this in full. That's 26W84243. You're overdue. We sent you an overdue notice. You're to pay in full by August the 30th. If you need more time, you come talk to me, okay? Or you can call the court if it's more convenient. We'll go on Zoom on or before any one of those due dates, all right?
Thank
Best
you.
of luck.
Thank you very much.
Luciano Hernandez, 268-166-62. Sir, your name? You're charged with fishing, possessing fish without a license. You have the right to an attorney. If you want one, I'll give you one. Do you want a lawyer?
Can I please speak to the prosecutor or pleading in your?
Yeah, I'll go ahead. So I'll arraign you and I'll enter a not guilty plea and send you to the prosecutor. You're charged with fishing without a license at Hurock Park near Arsenal in Flat Rock, June 20th, 26 at 7:27 p.m. They think you did not have a fishing license in your possession. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
You just sign, read, and understand the advice of rights.
Yes, Your Honor.
You plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial of any kind. Do you understand that? You still wish to waive your right to a lawyer? If you do, I'm going to enter a not guilty plea and send you to the prosecutor.
Okay, yes, Your Honor.
Is that what you want to do?
Yes.
I'll enter a not guilty plea. Personal bond, $100. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
Yes.
All right, you're all set. Thank you.
Thank you very much. Have a good day.
Lisa, do we have this case with the interpreter? Ms. Villarreal, which case are you here on?
I'm here on the Oscar Librado Huerta Nino case, Your Honor.
Have that in here yet.
Mr. Vitale spoke to the prosecutor.
Okay,
Yes, I did.
here it is. This is Oscar Librado Puerto Nino 26M690106A. All right.
Se llama el caso de Oscar Librado Huerta Niño, número de caso 26M690106A.
All right. Before we begin, Ms. Vitale, state your appearance.
Y antes de que
Thank you very
comencemos,
much.
señor Vitale, usted díganos su nombre.
Thank you very much, Your Honor. Stephen Vitale, P45601, on behalf of Mr. Huerta Nino.
Muchísimas
Ms. Vil-
gracias, su señoría. Soy Stephen M. Vitale, número de abogado P45601, representando al señor Librado Huerta Niño.
Ms. Villarreal, I'm going to ask you to raise your right hand. You solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant and his lawyer.
Yes, I do, Your Honor.
All right. And sir, can you tell me your name, please?
Y señor, ¿puede usted, por favor, decirnos su nombre?
Oscar Huerta Niño.
Oscar Huerta Niño.
We have a charge of driving while license suspended.
Tenemos un cargo aquí de que usted estaba manejando con licencia suspendida.
How does your client wish to proceed for purposes of arraignment?
Para el
He'll
propósito
stand
de
mute, Your
lectura
Honor.
de cargos, ¿cómo quiere proceder su cliente? Vamos a guardar silencio, su señoría.
He'll waive formal reading and stand mute, Your Honor.
Renunciamos que nos tengan que leer los cargos formalmente y vamos a guardar silencio, su señoría.
Court is entering a not guilty plea.
La corte va a procesar una declaración de no culpable.
I'm going to set a bond, sir. Your bond is going to be a personal bond of $500.
Y señor, le voy a dar a usted una fianza para que pueda estar libre. La fianza es una fianza de palabra de honor, es de $500.
You do not have to post any money,
Eso significa que usted no tiene que pagar dinero.
but you cannot leave the state without the consent of the court.
Pero usted no se puede ir del estado de Michigan sin tener el permiso de esta corte.
You cannot violate a law.
Y usted no puede romper ninguna ley.
You must appear in court as directed.
Y usted tiene que comparecer en la corte cuando se lo pidan.
Now, counsel, you're asking for a 4-week adjournment, correct?
Y abogado, usted no está pidiendo un aplazamiento de 4 semanas. ¿Es eso correcto?
That's correct, Your Honor, to have him pay up some Secretary of State fines, and the prosecutors indicated a willingness to give him a reduced charge as long
Eso
as
es
he can come
correcto.
back and show
Eso es
that.
correcto. Su señoría es para que él pueda ponerse en contacto con la Secretaría del Estado y pagar ciertas multas. La Fiscalía nos ha indicado que si él hace eso, están ellos más dispuestos a ofrecerle alguna oferta de resolución para la próxima vez.
So, Lisa, we'll probably have to go to the week of August the 18th
Yes, August 18th at 8:30.
at 8:30. August 18th at 8:30.
Así que su próxima fecha para comparecer es el 18 de agosto a las 8:30 de la mañana.
That will be your court date, Mr. Huerta Nino.
Señor Huerta Niño, sépase que esa es su fecha para regresar a la corte.
Thank you very much, Your Honor.
All right, we'll see you guys here then. Thank you very much. Have a great day, all of you. Thank you.
Gracias a todos. Gracias
also.
por haber venido hoy. Los veo para la próxima vez. Your Honor, will this be in person?
No, you can appear by Zoom if you want. Are you going to appear by Zoom, Mr. Vitale?
Please, that's preferable. Thank you, Your Honor.
I just need him in your office with you.
That's the way I'll do it again, Judge.
Así que
Thank
para
you.
la próxima audiencia vamos a comparecer de nuevo por Zoom y usted va a estar en la oficina con su abogado.
Thank you,
You're
Your
all
Honor.
set. Thank you both.
Ya listo. Thank you, Your Honor. Have a great day.
You too. Counsel, which one do you have?
Your Honor, Stevie T.
Oh. Okay. Stevie Vukalaj, 26B710812.
Ren Nusha, appearing with on behalf of Mr. Tida to right.
So we're going to trial, huh?
Yes, sir.
July 24th.
Yes, sir.
Is this, you're doing this with Ms. Holloway, right?
Yes, sir.
Call in Ms. Holloway, will you, John?
Good morning, Your Honor. Nora Alley on behalf of the people, PA 6528.
Your name, sir?
So,
So we're going to proceed to the jury trial on the 24th, correct?
Yes, sir.
Yes, Your Honor.
So what I'm going to need from you, again, the same thing, the same jury instructions that you guys agree upon.
Yes, sir.
Book ready for me to put it for my recorder assistant to put in the books for the jurors. Okay, can I have those
Your
no
Honor.
later? So this is next Friday.
Yes, I will be in the office
Jury
this week. I
trial in the
can
middle
get
of
it
the
to
summer.
you.
You guys can't figure out something else or?
We've asked.
Your Honor.
So-
A plea offer was given, but unfortunately it wasn't taken. If you recall, my supervisor authorized a certain plea, like the last
That's
case
fine.
we had.
If you can't, it's all right. I like jury trials. I need those instructions by Monday, though. Will you get them to me by then, Ms. Holloway?
Yes, Your Honor.
Yeah, so, and we're gonna start at 8:30. Okay, I don't wanna leave anybody waiting. So jury instructions due by July 20. And we'll start next Friday, July 24th, 8:30 in the morning. Have a good day. Thank you all. Thanks.
Thank you.
It's Holloway. Which one do you have, Ms. Gay?
Yes, Your Honor. I'm here.
Probation violation. Which one?
Amber Russell, Judge?
We'll do that one now. Amber Elizabeth Russell. 26B02-516.
Good morning, Judge. Madeleine Gate, apparent back, Ms. Russell.
Ma'am, your name?
Member Elizabeth Russell.
You were in here for a violation of probation. On June 25th, I arraigned you on the charge. The charge, count one, failure to refrain from consuming alcohol or drugs testing positive for alprazolam through DNA on that charge. On that date, May 11th. How is she going to proceed here, counsel?
We're gonna take you.
I'm going to need you to call in Jessica, somebody. Is that what you want to do?
Plead guilty, sir?
Yes.
Sure.
If you plead guilty here, that'd be your first technical violation. You could receive 5 days in jail. Understand that?
I do understand.
And did you sign, read, and understand an advice of rights form here this morning?
Yes, I did, Your Honor.
If you plead guilty, you will be giving up all those rights, and we're not going to have a hearing. Do you understand that?
I do, Your
Do
Honor.
you have any questions before I ask you how you plead?
No, I do
To
not.
the charge that you failed to refrain from consuming alcohol or drugs testing positive for Xanax, alprazolam, May the 11th of 26 at DNA.
Correct, Your Honor. I plead guilty.
Did you consume
Yes,
Xanax, say within the 3 days before that?
yes, I
And
did.
you did not have a prescription, correct?
I had a very old prescription and I did not even think
It was
twice.
Right, okay. So you had that, you've been prescribed that in the past, but not recently, correct? All right. Has anybody forced you to plead guilty?
No, Your Honor.
Accept your plea to the charge that you tested positive for alprazolam on that date of May the 11th. Ms. O'Donnell,
Just hold on, Your Honor.
your name. Okay, thank you. What do you want to say? I'm asking you.
Oh, Judge, there was a pill left over. She was feeling a little anxious, so she took it. She didn't have a current prescription, Judge, but otherwise, this is her first violation. She's completed all of her other conditions short of the anger management class, which she is attempting to register for, but hasn't received the registration. Isn't that correct?
Correct.
But otherwise, Judge, I mean, she's been on track. We asked the court to take that.
How's she doing with everything else?
Her 16 hours of community service not completed. She shows up for testing. I think she does still have a balance left at this point. The only thing other than that she has left is the anger management class with the 4-week follow.
As far as the balance, I would say, I was under the impression that was completely paid off.
So was I, Your Honor.
Can you check on that at least?
I didn't check it out this morning, so.
I'll check. We'll check.
I'm sorry, what was that?
The question is whether or not she's paid off her balance,
Oh,
Ms.
yes.
Russell.
Yep, she's paid in full.
Okay. Anything else, Ms.? No?
So the only problem I have is, so she does have a benzo prescription. So generally, when she goes for testing, because she has a benzo prescription, we generally would pay for the lab, because she does have a prescription, not for Xanax, so. My recommendation is that every other test or so, we pay for the additional lab to find out if it is actually the prescription she's prescribed, or if it is, we're taking Xanax again. Because that's my problem. That's how we found this out. They actually weren't supposed to lab it. They labbed it on accident, and that's how we found out she was taking Xanax when she shouldn't have been.
Judge, I would also note that she did also test positive for fentanyl, which also came back negative. So because of that, it could create a false positive.
Again, this is a lab confirmation, though the lab confirmation was confirmed.
What do you want me to do?
So technically, when she goes for for testing, they won't have her pay, they'll only have her do the instant test. They won't have her pay for the lab when she tests positive for benzos because she does have an active benzo prescription. I would ask that maybe every other test or every third test, she pay the additional $25 for the benzo lab so that we can see if it is actually her prescription that she's supposed to be taking or if she's taking something else like Xanax that she's not supposed to.
He's only testing monthly now too, right? Defendant to test bi-weekly. Defendant to serve 8 hours of community service by August the 7th. Defendant to pay for lab confirmation every other test. So every other test, you're gonna have to pay for your lab confirmation, which is the extra $25. You have to do 8 hours of community service by August the 7th. And you're gonna test bi-weekly, okay?
I understand.
And otherwise, I'll continue you on probation.
Thank you.
Good luck. Thank you.
Thank you.
Good morning once again, everybody. Happy Tuesday and welcome to TCF Live. My name is Dan. It is good to have you all here. We'll keep an eye on Judge McNally, of course, but let's change it up. Let's go to Newaygo County, Michigan. Robert Springstead. Looks like we're going to do a sentencing.
Mr. Welburn, you indicated to the court earlier that Ms. Mishler was going to be present in court, but she didn't want to speak. But there was a statement that you wanted to read?
Yes, Your Honor. She provided us with a statement to read to the court prior to sentencing.
All right, why don't we do that now?
Okay.
Your Honor, I will read the victim's statement. Dear Honorable Judge Springstead, my name is Amy Jo Mishler. I'm the victim in this case with David Rodriguez that occurred on October 29th, 2025. What I'm about to tell you is not a single incident or a moment of poor judgment on the part of the defendant. David has demonstrated a pattern of violent and aggressive behavior towards me that has caused me significant physical harm, emotional trauma, and financial loss. His actions are deliberate, calculated, and premeditated, a systematic campaign of terror, violence, and control that began within weeks of meeting him. Before I met the defendant, I had goals, a purpose, and I was at peace. I was secure and happy, and I was at a point in my life where a long-held dream was finally in reach, and I was taking real steps towards it. I created a business plan to run my own businesses from home, refinishing furniture. I had a portfolio of work that I already did, and I had family photos of me and my late father together. Saved on my phone pieces of life that I would never get back. David destroyed it all. He destroyed 5 of my phones during the time we were together. I met David in the middle of August 2024 when my life ended and became his. Within 2 weeks of meeting him, I needed to set boundaries. David started parking in my driveway every morning, waiting in his truck for me to come home from work. When I told him to park there only on my days off, his reply left me feeling intimidated. He was going to do whatever he wanted, whenever, wherever, and no one was going to tell him otherwise. I had no say. Later that same night, I tried breaking up with David, explaining to him it's only been a couple of weeks, so leaving is better now than later. He told me, shut up, I'm staying, and I'm not going anywhere. I had no say. On September 24th, 4 weeks in the relationship, the violence and destruction had begun. David began swearing, talking down at me, calling derogatory names, degrading and humiliating me. He was angry and aggressive, breaking nearly everything in my home. He's broken windows and doors with the frames and locks, and a full-length mirror, cupboards, dishes, keepsakes, fans. He's left holes in the walls. He damaged my new car by throwing a brick at it. On 2 separate occasions, he's broken 2 pairs of my prescription glasses while he was smacking me in the face. I'd go to work with black and blue eyes, cut swollen lips, and bruises all over my body. His manipulation, cruelty, and criticism was constant, and I was walking on eggshells, never knowing when his rage would surface for he never needed a reason or trigger. On October 9th, 2024, 8 weeks in, David was beating me again, and this time I was able to call the cops. He spent the night in jail and a PPO was issued, but I still wasn't safe. He came back with a vengeance. David would call and text me, leaving hundreds of threatening and vile messages. I would block him and he would call me from a new number. I have 16 new numbers from him, and in one 8-hour workday, David called me 1,078 times. If I didn't answer, he would plan and pay for an Uber ride 30 miles to my house to punish me. I never knew when he was coming, but he always did. One night I was sleeping, he entered my locked home and woke me up by pulling me off my bed and dragging me through the house by my hair. He started punching and choking me. I looked up at him and he was smiling. I asked him what he thought was so funny, and he said that he liked it. And then lunged toward me and kicked me in the stomach, breaking my rib. David took pleasure in my pain. November 2024, 12 weeks in, I came home from work and David was hiding in the shadows behind my garage. As I walked into my home, David came up behind me and followed me into the house. I told him to leave, but he said that he owned me and I was his property. He said that I needed to be punished. David grabbed me and threw me to the floor with such force that I suffered a concussion and missed 3 days of work. In 2025, the beatings and emotional blackmail continued. The terror, violence, and threats of him wanting to kill me didn't stop. He would tell me that he wanted to smash my head in and have my brain splatter all over. And then he would take a baseball bat and swing it at me and stop 1 inch from my head, and he would laugh. I was living in fear. My body would shake uncontrollably. I lost weight, suffered severe headaches, and I was exhausted in ways that I've never known. My stomach is in knots, and I'm full of anxiety. My heart raced every time the phone rang, and I was easily startled, jumping at every loud noise or quick movement. I was in constant pain from his beatings. I could never do anything right, and everything was my fault. But then he would apologize, promising he would never beat me again. He would tell me that he loved me, but I would never say it back. He would slam me up against the wall and force me to say it. David sent me videos and photos of him cheating on me, having sex with other women. He sent me videos of him and me together that I never knew existed. This level of betrayal profoundly devastated me, traumatizing me so deeply that even time can't heal this. On October 13th, 2025, I was nearly killed in a car accident that resulted in my admission to the ICU. I was being monitored for heart failure and collapsed lungs. I had 5 broken ribs and a broken sternum. On October 29th, 2025, when I was home, recovering from the accident, David came into my home uninvited and had every intention of making good on his promise to kill me. He started beating me all over my body and strangled me with his belt. The cops were called, a report was made, photos were taken, his belt was put in evidence, and a second PPO is active and a warrant was issued for his arrest. For 4 months, I waited. David evaded arrest, I had the locks changed, and my door added a deadbolt. Security cameras were put up on my property, but despite the second PPO, he kept calling me at work, threatening to finish me off, to kill me and my family. During that same time, he was terrorizing other women the same way he did me. One of the women made a report, but no charges were made for a deal in this case. Since his arrest on February 25th, 2026, with a no bond order, something has slowly begun to shift in me. Although I don't jump anymore when hearing loud noises, I still keep my phone on silent. I don't check my windows looking for danger before going outside. For the first time in over a year, I feel close to safe. The safety only exists because David is behind bars. I want to heal, I want peace. The house I used to call home, I want to find a place that is quiet and private and somewhere I can truly feel safe. I want to build a business. I want to find the woman I was before he destroyed me from the inside out. Your Honor, I am respectfully asking you to oppose the maximum sentence available, not out of revenge, but because I know what David is capable of. I also know I'm not his first victim, and without significant consequences, I will not be his last. Sincerely,
Thank you. All right, Mr. Prysock, have you had the opportunity to read the report and discuss it with Mr. Rodriguez?
I did, Judge.
Do you have any additions, corrections, or challenges?
Judge, the only question we had was we had a COPS agreement. Court agreed not to exceed 5 years. And the original plea agreement had the guidelines that 34. The Cobb's agreement, prosecutor had him at 38. I scored him a little lower at 30. Mr. Zurup had them at 43. So given the fact that the guidelines are kind of all over the range, it's still within the range of the Cobb's agreement not to exceed 5 years. So other than that, Judge, I don't have anything else. So we found that the report was accurate.
All right, is there anything that you want to say on his behalf other than what you've said so far?
No, Your Honor, thank you.
All right, and Mr. Rodriguez, have you had the opportunity to read the report and discuss it with Mr. Price?
Yes, sir.
Do you have any additions, corrections, or challenges?
Nope.
Anything that you want to say on your own behalf?
I just want to say I apologize to the victim and her family. I've never forced her to be around me. We've been on dates throughout all this time. As a matter of fact, the day of October 27th, 2 days before all this occurred, the whole week before that date, we were not talking, we were not communicating, but she was sending me pictures of her accident, of her car, and making me guess if I was in there. I didn't recognize her car, but she made me guess, just play this game. Oh, maybe I was in an accident, maybe I wasn't. You wanted me dead, you wanted this. And I told her, of course I didn't. And she actually invited me to her house October 27th, and I spent the night. I walked her to Dollar General, and I thought everything was fine. Other than that, all I can say is she's just, I'll accept responsibility, but she's really trying to just, run me down and make me seem like a monster, but I'm not. We've had lots of dates, lots of times where we were just vibing together at her house or wherever I was. She came over where I went, wherever I stayed many, many times on her own, just on her own. But all I can say is in prison, I will continue to address and correct my behavior to better myself and get my parole when eligible. And I'll pick up where I left off, getting my life together.
So as the prosecutor read her impact statement, what were you thinking?
I'm not gonna sit here and say I was perfect. I mean, I know I wasn't, but I'm not gonna sit here and say that everything she's saying is exactly accurate, because she's just, I don't know where she's getting a lot of this from. Time after time, she asked me to come over, telling me I love you. Would come over after work to wherever I was. I was living in Grand Rapids for almost 2 years, and I'm just kind of like, appalled by a lot of what she's saying, because I've never forced her to come to me or anything like that.
Well, that's the saddest parts about people that are victims of domestic violence. And one of the cruelest part of someone that is an abuser is that it gets this codependent type relationship. And as it indicates, she couldn't, the horrible cruelty with all the apologies and it'll never happen again, and the makeup and all that kind of stuff. It's a horrible cycle that they go through, that abusers put them through. So the kind of reality gets distorted. But you're telling me that you didn't do that sort of thing, that what she said is she's making all that up?
No, I didn't say that. I'm saying a lot of it is she's making it up.
Okay.
Like she's, you said, I've never, she told me that she had a husband before that did 10 years between, but they had a bunch of domestic violences. She told me that she had domestic violences of her own. She went through something with her first husband. He was very violent. And, I'm not going to sit here and try to call her out on all her stuff, but I believe that she likes the type of toxic relationship. She always told me, I'm toxic, you're toxic. It's something that I don't know. I think that she enjoys, but I don't enjoy this. I'm not enjoying sitting in jail. But like I said, I'm not perfect, but I'm not going to sit here and try to not to accept responsibility for this, because then you're just going to look at me like, oh, he's just heartless and all that. And, that's not enough. I've been sitting here since February. I've been trying to work on myself, and I'm going to continue to work on my behavior. We're all done. I'm all done. All I can do is move on.
All right, Mr. Walburn, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
We just asked the court to comply with the terms of the plea bargain. I think the court knows more about this than they do most cases. Mr. Price and I had a prelim to explore some of these issues. We tried to supply the court with some of this information when we did our comms memorandum. I pulled excerpts from the police report. So we just asked the court to impose a sentence in accordance with the plea bargain.
The court recognized that the advisory guidelines suggest a sentence between 43 and 114. The courts can exercise my discretion. Sentence consistent with the plea agreement, consistent with the advisory guidelines, and consistent with the Cobb's agreement in this case. Would be the sentence of the court. This defendant served 5 years on the minimum to a maximum of 20 years with the Michigan Department of Corrections. To give him credit for the 140 days that he's already served. There's a $68 state cost assessment, $130 crime victims' rights fund fee, no credit with the victim, or no contact with the victim in this case. Court ordered that the financial assessments be collected through the inmate account and parole process. You've been to prison before, Mr. Rodriguez?
I went in 2018 to quarantine for 60 days, and I went to SAI boot camp, and I got out on parole and completed parole without any violations.
I'm guessing that you're probably going to run into somebody in prison that treats you like you treated her. So maybe you get to see it feels like you're powerless in this situation. You do have the right to make application for leave to appeal your conviction sentence. If you're not assured attorney, the court appointed attorney will put you on the appeal request for waivers to the court within 2 days.
Your Honor. This one. Get back to the court if you want them to appoint an attorney for the appeal, okay?
So a couple of things that stood out there. First, the Cobb's agreement was for 5 years. He gave him 5 to 20, so he exceeded the agreement. And then at the end, he advises the guy, hey, just to FYI, I'm willing to bet you're going to see people in prison who will treat you like you treated her. So, interesting. Now it looks like he sat back down. Do we have more to say?
At 19 to 76 months, we would be willing to cap the maximum of the minimum at the midpoint of the guidelines.
All right, Mr. Prysak, that appears to be the same offer that we discussed on June 16th. Have you had a chance to go over that again with Mr. Gifford?
I did, Judge, if you could just give me a second.
Oh, yeah. Different contestant. You're right, Wahoo. But we're here, so let's run with it.
You want to set up for trial? You want to set it for a trial? Or you want to plea? Pardon me? He's going to go within the guidelines, which, as I told you, 19 to 47. So, do you want to enter a plea? Or you want to set it for trial? Pardon me? Okay, let's leave by the rights, whatever. So go ahead and sign it right. Best thing we possibly can. Judge, Mr. Gifford's going to enter his plea pursuant to the plea agreement.
All right, and Mr. Gifford, would you raise your right hand, please? Do you solemnly swear oath or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, so Mr. Walburn, point of clarification, you indicated he's going to enter a plea of guilty as charged. That includes the habitual offender 4?
Good, Your Honor.
Okay. That's your understanding as well, Mr. Prysock?
Yes, Judge.
All right, so Mr. Gifford, the charge that you're entering a guilty plea to reads as follows: that on or about April 28, 2026, that you were in the city of White Cloud, Durango County, state of Michigan, and that you committed perjury, that you were lawfully required to depose the truth as a witness in a suppression hearing, court proceeding in the case of Troy LaFerriere, the case being firearms possession by a prohibited person in the 27th Circuit Court, that you did commit perjury by testing it as follows. Mr. Raymond Gifford Jr. advised that Troy LaFerriere never sent him a topless photo of a minor female, and that he never spoke with the officers regarding the photo. This is contrary to MCL 7504.422. It's a felony, which goes up to 15 years in prison. Understand count 1 in the maximum penalty.
Yes.
You'd also be admitting to being a habitual offender 4, which means that you have at least 3 prior felonies. Do you understand that?
Yes.
Or felonies or attempted to commit felonies. What it indicates here is that on or about April 19, 2026, you were convicted of the offense of attempted telephone cutting, tapping lines, contrary to MCL 750-45540, in the 78th District Court for Laredo County. Do you have that prior attempted felony conviction?
Yes.
Your Honor, I'm sorry to interrupt. Just for clarification, I'm looking at our information. This is 2026. I think it was 2006. I'm looking at a CCH. That is a typo. It is 2006.
Okay, does that make sense, Mr. Gifford? That was in 2006, about 20 years ago?
Yes.
Okay. All right, and then on or about May 26, 2015, failing to pay child support here in the 27th Circuit Court from Laredo County. Do you have that felony conviction?
Yes.
And looks like April 4th, 2016, criminal sexual conduct, 2nd degree, person under 13 during the 27th Circuit Court. Do you have that as well?
They convicted me of that, yes.
Okay. So therefore, with this habitual offender 4th, you're facing the possibility of life or any term of years. Do you understand that?
Yes. Can I ask a question?
Yes, sir.
Isn't there a cap on my sentencing?
Yeah, that's just the max.
Okay.
So the habitual offender increases the potential maximum penalty. Okay. The other part that you're talking about is the cap of the minimum sentence. So at sentencing, you would get what's called the indeterminate sentence. I would set the minimum sentence. Let's just say, looks like your midpoint would be 47 months. So it's set your minimum sentence at 47 months. Then I would pick a maximum sentence, 20, 30, 40, could be life. I'll pick a maximum sentence, but your minimum sentence drives your eligibility for parole.
So the minimum I'm going to get is 47 months?
So I said just for example.
Oh, okay.
So the habitual offender impacts your advisory guidelines, but it most importantly impacts the possible maximum sentence that I can impose. Because under the statute, it's 15 years, but because you have prior felonies, the court's going to have the option to increase your maximum penalty beyond that. You understand how that works then?
Yes.
Okay. So then the other part that you're interested in is that you have a sentencing agreement that any sentence that would be imposed would, number one, be consistent with the advisory guidelines. The prosecutor indicated that he scored those at 19 to 76 months. He could be right, he could be too high, or it could be too low. Your agreement is that you be sentenced to no more than the midpoint of the advisory guidelines. So if the prosecutor accurately scored the advisory guidelines, then the midpoint would be in the neighborhood of 47 months. So what that means, to be sentenced consistent with the advisory guidelines. The least that you could expect would be 19 months. The worst that you could expect would be 47 months. And then the court would pick a maximum penalty anywhere between 15 years and life. Understand that? Okay. You get credit for any time that you spent in jail so far against that eventual sentence. Understand that?
Yes.
All right. Is that your complete understanding of the plea agreement in this case?
Yes.
Have you had sufficient time to consult with Mr. Prysock about your charges and this plea agreement?
Yes.
Subject to the plea agreement, how do you wish to plead?
Guilty.
Do you understand that if I accept your guilty plea, you're giving up your right to have a trial of any kind?
Yes.
Do you also understand that you're giving up certain rights that you would have at your trial?
Yes.
We listed those rights for you on a written advice and right sheet that you signed today. Did you read that document?
I read it through with this.
Did you understand it?
Yes.
Have you gone over those with Mr. Prysock as well?
Didn't go over them with them, but I understand them.
Okay. So I'm gonna read each right, and then you can respond if you understand that you're giving up that right or not. Do you understand that you're giving up the right to have a trial by jury?
Yes.
To be presumed innocent until proved guilty?
Yes.
To have the prosecutor prove beyond a reasonable doubt that you are guilty?
Yes.
To have the witnesses against you to appear at the trial?
Yes.
To question the witnesses that the people would call against you?
Yes.
To have the court order any witnesses that you would have for the defense to appear at the trial?
Yes.
To remain silent during the trial? To not have your silence used against you?
Yes.
And to testify at trial only if you want to testify?
Yes.
You also understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial?
Yes.
Further, any appeal from your conviction and sentence pursuant to this plea will be by application for leave to appeal in the Court of Appeals, and it's not an appeal by right. Understand that? All right. Has anyone threatened you to get you to make this plea?
Not to take the plea, no, but the reason I lied is because I felt threatened. And ultimately, I thought I was doing the right thing by helping someone that I thought was in dire harm, being trafficked, basically. You see the signs all over, see something, say something. And then when I said something, I was supposed to be anonymous, and it became public knowledge. And I was put on the stand in front of a hardened criminal, gang member that brags about how he just beat an attempted murder charge in Lansing. And I just felt like a deer in the headlights and was scared.
Okay, we'll get to that when we talk about what happened that makes you guilty of this. But the question is more focused than that. Is has anyone threatened you to make you plead guilty to it?
Just the time of the habitual. I don't have time to do 15 years of life. So no, no one personally, no.
Okay, so typically when a defense attorney talks with a defendant about a potential plea, part of that discussion is, look, this is what the prosecutor is offering you. This is kind of a worst case scenario. If you go to trial and lose, this could happen, those sort of things. And then people make an informed choice to either plea or go to trial from there. Is that the process that you're describing here?
Yes.
Okay. So no one's forcing you to enter this plea.
No, it took me a while to do it because I was aggravated over the whole circumstance. When I was in prison, I done everything, took every self-help group, done everything to better myself. When I thought I was doing the right thing.
Okay, but as far as your decision to enter,
No one threatened me, no.
Nobody threatened you?
No.
You're kind of making the best out of a bad situation.
Yes.
Okay. Has anyone promised you an outcome different than what you put on the record today?
No.
Are you entering this plea of your own free will?
Yes.
Do you understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice?
Yes.
Do you understand that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea?
Okay, I didn't know that. Yes.
So if for some reason, I look at this facts and circumstances and I look at your record and I go, oh man, midpoint to the advisory guidelines is not enough. I want to give you 8 years. You could say, hey, look, Judge, that wasn't the deal. And then you would be right. You wouldn't have to go through with it because I broke the deal. You're not stuck with it. You understand that?
Yes.
I'm not saying that's going to happen, but that's how that would have, okay?
Yes.
All right. So you understand that, that I'm not bound by this agreement, but if I don't go along with it, you can start over.
Yes.
You have the right to have a trial and all that. Do you
I
understand
didn't
that?
know that, but now I do. Yes.
Okay. Do you now give up your right to have a trial of any kind and all the rights you would have at the trial, and you still want to plead guilty?
Yes.
Are you pleading guilty because you are guilty of this, or is there some other reason for offering a guilty plea?
I am guilty of it. I done it.
Okay. So, back on or about April 28, 2026, were you in the city of White Cloud, Newaygo County, state of Michigan?
Yes.
And were you called as a witness in the suppression hearing regarding the case with Troy LaFerrier?
Yes, but I think it was the 28th, wasn't it?
April 28, 2026.
Oh, okay. I thought you said 26th.
I could have, but I'm reading it off it. So the date says on or about April 28, 2026.
Yes.
All right. And you were called as a witness in that suppression hearing. Is that right?
Yes.
That involved Troy LaFerrier.
Yes.
And were you given an oath to tell the truth during that hearing?
Yes.
And you agreed to do that. Is that correct?
Yes.
All right. And there was the suppression hearing was involving charges regarding Mr. LaFerrier for being a prohibited person having a possession of a firearm. Do you understand that?
Yes.
All right. And was it the prosecutor or the defense that called you as a witness in the case?
Defense.
Okay. And before providing testimony, did you have contact with Mr. LaFerrier?
Yes.
And was he telling you what he wanted your testimony to be?
Yes.
All right. Was he out on bond when that happened, or was he in
He
jail?
was calling me from jail.
Okay, so this discussion occurred over the phone system there?
Yes.
All right. And what was it that Mr. LaFerrier wanted you to testify to?
Just to say I didn't know anything about it.
All right. And did he also tell you to say that that you had never talked to the police investigators in this case?
Yes. I told him that I didn't because he's not a good person. I was scared for my well-being and potentially my family. He knows where a lot of my brothers and sisters live too.
Okay, so he asked you to lie about what?
I told him that I didn't have a clue of anything about it. I tried to play stupid and he said, well, just tell him you don't know. Tell him you didn't have no part of it, which that's what I done.
All right, so so your false testimony was that you indicated that Troy LaFerrier never sent you a topless photo of a minor female.
Yes.
That's what you testified to at the hearing, is that right?
Yes.
And what was the truth of that statement?
That he did. And a friend showed me on Facebook that the girl's family was looking for her, and I was under assumption that she was like a teen in need, and so I just was sitting there thinking, the right thing to do is, he's a 50-something-year-old man, career criminal that brought this girl hours away from her home out to the middle of the woods, and it's like, what's next? So I felt like I had to do something.
What were the circumstances that led up to him sending you that topless photo of the minor female?
I was at a friend's house sitting while they were gone and taking care of their animals, and he told me that the police were there looking for him because they wanted his Jeep, and I didn't know anything about the girl at the time. And then he told me about her and wanted me to come and pick them up and take them from his home so he could avoid the police. And at the time, I didn't want to do that, period. He wanted me to bring him and her to my friend's house where I was house sitting. And I told him, no, absolutely not. And he just kept going at it and going at it, kept harping me about it. And I just kept telling him, no, no, no. And then he sent me that picture, like trying to, I don't know if he was trying to entice me, or I really don't know why he sent me the picture, but that's what broke the camel's back. You know, I'm like, I don't even want these kind of pictures on my phone. And it just kept going and going, wanting me to come pick him up. And so I just, that helped lead me to my decision on trying to help the girl out, after the girl's family even drove 4 hours away trying to find her.
Okay. And then when you got that picture and you knew that the family was looking for, did you then reach out to somebody that you knew in law enforcement?
I reached out to my friend, and she used to be in law enforcement, and I asked Jessica Buscano.
Okay.
And she knew a gentleman, Mr. Fritzma, and she then sent a picture to him to make sure that was the right girl. And then he called me and spoke with him, and he promised me that I wouldn't be getting brought into it, like anonymous, you know, it's an anonymous tip, you know, here she is. And then I got brought into it.
Okay. And then when you testified, you indicated that Mr. LaFerrier never sent you the topless photo, and you also lied and said that you hadn't talked with the police.
He was right there staring at me.
Mr. LaFerrier was right there staring at you?
Yes.
Okay.
So now when I do go to prison, I have to worry about it just as bad in there. You know, as potential gang members coming after me.
All right. The attorney is aware of any promises or inducements which have not been stated on the record?
No, Your Honor, there are none.
Is he competent to enter this plea?
Yes, Your Honor.
He is.
And has the court complied with MCR 6.302?
I have, Your Honor.
Court has.
All right, the court finds the plea to be knowing, understanding, voluntary, and accurate. I'm going to refer Mr. Gifford to the probation department for the preparation of the pre-sentence investigation report. We'll set sentencing for August 25th at 9:20. So Mr. Gifford, Mr. Zirif is going to get you a packet of information for you to fill out. Then they'll do an interview. You've had one of those done before, pre-sentence, and then they'll make a recommendation to the court at the time of sentencing. All right?
All right, thank you.
That's all for today.
Going to see you before.
So yeah, team, perhaps we get that one up on the calendar and we can see if we can catch that sentencing. Good morning once again, everybody. About to enter hour 2 already of TCF Live on this fine Tuesday. Let's go to Florida, Wade Mercer, and we'll check in with him.
This case is first. The first one on the list is Terrence Ferguson. Ferguson, good morning, Mr. Ferguson. You've got a couple of friends or family members in the courtroom. You're here because you've been accused of one count of failure to return leased property with a value of over $300. Mr. Ferguson, there is probable cause for the charge. I've looked at your criminal history. You've got several prior charges, but I don't see anything pending, and I don't see any probation as far as I can tell. So I think you're entitled to a bond, but I'm going to listen to the attorneys before I make that final decision. Mr. McDaniel, anything on behalf of Mr. Ferguson?
Judge, just if he's, eligible for maybe a cash bond, you would ask for one if that's an appropriate action.
Thank you, Mr. Mitchell.
If he wants to post cash bond, we don't object.
Mr. Ferguson, I'm going to set your cash bond at $500 cash. That's based upon your history and you're charged with a third-degree felony. So his bond is $500 cash. Now, the good thing about a cash bond, I'm talking to your family members, is if you post that or if someone posts that and the case is dismissed, it's returned to whoever posted it. If you post it and it's not dismissed and there's court costs and fines or restitution ordered, it goes towards court costs, fines, or restitution. So it's $500 cash, and that cash bond is posted, he'll be released. I'm also going to give him notice for his court date. Ask the jail to give him notice for his court date, which should be August the 4th at 8:30. They'll give him a written notice. They'll give you that notice, Mr. Ferguson. And you also have a condition to have no contact with that rental center that's the alleged victim. Mr. Ferguson, do you have any questions?
No, sir.
Does the family have any questions? I wish you the best, Mr. Ferguson. We also have Caleb Vickers, who has friends or family here. Mr. McDaniel. Ms. Vickers, good morning. Ms. Vickers, your mother, is it mother? Your mother's in the courtroom. Ma'am, you're here because you've been accused of one count of exploitation of the elderly less than $10,000 and one count of fraud, obtaining property under $20,000. Those are both appear to be third-degree felonies, Ms. Vickers. I don't see any prior criminal history, but the charges against you are pretty, there's significant evidence, it appears. So, Ms. Vickers, I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys and I'll set your bond or your release status. Mr. McDaniel.
Your Honor, we just asked for, the court to, possibly if it's eligible for a conditional release or a cash bond. I know she had no criminal history. I don't recall how bad the complaint was.
Thank you. Mr. Mitchell.
We'll leave it up to the court to determine the reasonable release option, but if she does want to take a cash bond, we don't object to that.
Okay. So, Ms. Vickers, I'm not going to give you a conditional release because there's significant evidence against you, and the charge is a disturbing charge. But I'm also not going to set you the regular bond because you have no history. I'm going to set you what normally would be a misdemeanor bond. It's kind of a compromise based on your lack of any history. Your bond's going to be $250 cash per count. She's got 2 counts. So, ma'am, what that means is there's a $500 cash bond for her. She posts the cash bond, she'll be released. She has a condition of absolutely no contact with the alleged victim, none at all. And it's a $500 cash bond. You also be giving you notice for your court date at the jail. That'll be August the 4th at 8:30. They'll give you that notice in just a few minutes. I'm talking to your mother, ma'am. Do you have any questions? All right. Ms. Vickers, do you have any questions, ma'am? Any questions?
She shook
Oh,
her head.
all right, man. Wish you the best. We do also have Mr. Johnson's mother, Hayden Johnson. Mr. Johnson, your mother's in the courtroom. Mr. Johnson, you're being brought back up just to kind of keep an eye on the case and see where things stand. I know that Mr. McDaniel, based on the email he sent, he's been kind of trying to work on this and try to find you a different placement option that's acceptable. So let me listen to Mr. McDaniel and we'll see if your mother has any questions. Mr. McDaniel.
Your Honor, we're working on possibly getting him over to the Haven House. So we just, we understand the court's going to hold with that bond right now. And hopefully next week we'll find out more. And, it may take a week after that, but we're working on it.
Thank you, Mr. McDaniel. Mr. Mitchell, anything?
No, Your Honor.
In the courtroom, ma'am, do you have any questions? All right. Mr. Johnson, do you have any questions?
No, sir, not that I know of.
All right, Mr. Johnson, Mr. McDaniel's working on your case. I don't remember the Haven House. How long is that program, Mr. McDaniel, Mr. Mitchell?
It's a 9-month
6
program, if I
months?
recall. And I believe it is 9 months, 6 to 9 months, something like that.
Where's that one at?
Yes, it's over in Okaloosa County. And it's I still don't say, it's the drug program. I don't think he has a drug problem, but
I was just drinking.
That's all right. Hopefully it works out for him.
Okay. All right, so we'll see you at your next court date, which will be when, Mr. McDaniel? I know you may bring him up before this date, but what date do you want him scheduled for?
He's already on the August pretrial docket, and I'll just leave him on there for now in case that he does get out before, and we're going to pass it if he's in there. So we're not going to change his court date for now.
All right, thank you, Mr. McDaniel.
20th?
August the 12th. Mr. McDaniel, any questions, ma'am?
That's the jail pretrial docket. We put him on the regular out of custody pretrial docket. I was just going to leave him there for now. You can change him to the jail pretrial, but
We might have to, given
he's got no bond, so let's put him on the jail one, which is what? August the 12th. I think his mom has a question. Yes, ma'am. Yes, let's say if there's ever a jail sentence imposed, he'll be in credit. If there's a jail sentence imposed, he'll get credit for the time he's doing now.
Say we have it a month, we'll get credit, that credit or still?
Not towards the program. The program doesn't give you credit for time unless you're in the program. So if he goes to a 6-month program, it's going to be from when he starts. Okay. If he'd stayed where he was at, he'd be getting credit right now, but he didn't. Thank you, ma'am. So, Mr. McDaniel, that's it for friends and family in the courtroom. So we'll go back to the top of our list. First case is Marcos Peraza. Mr. Peraza, good morning. You're here because you've been accused of 4 charges. You've been accused of bringing unauthorized Schedule I controlled substance into the state, possession of over 20 grams of marijuana, possession of paraphernalia, and driving while license suspended or revoked. It says second or subsequent, but I don't think I saw that prior in the charge in the complaint. But Mr. McDaniel, I think based on your email, you had some probable cause issues or perhaps concerns you wanted to raise.
Judge, it's a close call, and it's basically, obviously the case law says you have to have more than the smell of marijuana. I don't recall if the complaint had in there that he's got a license for medical marijuana, but he's got a license for medical marijuana. And allegations were, that basically when I would probably argue that he was being questioned un-Mirandized in a custodial kind of fashion, especially when he has warrants out for him and he's driving a suspended license. Questions about it. And he says, he had smoked some in marijuana in Alabama when he was driving through there, which kind of led to the first charge. Also led to a very kind of paraphernalia charge that basically says because he had used a paper that the marijuana was wrapped in, or in the lighter, that was paraphernalia. I thought all those drug charges were questionable.
Thank you, Mr. Mitchell.
Your Honor, I can't remember exactly which case it is or the exact verbiage, but I believe the case law says that what we need for that is the smell +1 is what it is. And even in the complaint, it says that there was a detection of a strong, distinct odor of burnt marijuana emitting from the vehicle. The officer asked, and that's when Mr. Peraza actually presented the bag containing the dispensary logo on it. And that's where basically we contest that's the +1 in this situation as it pertains to any probable cause issues that may come in there. I believe that could be something that is not addressed for probable cause purposes, but maybe for a motion to suppress at a later date, but we just contest that there's probable cause.
So thank you both. So Mr. Peraza, there is some concerning language in here. Mr. McDaniel's right. There's no reference to a Miranda. It appears there may be some issues. The problem you have, number one, it looks to me like someone had missed a Bay County warrant. You've got a warrant out of Bay County, same name, same date of birth in 26-1939 CT. So I need y'all to double check that, Lieutenant. I think he's got an active Bay County warrant that has a $1,500 bond on it. Number two, he's on probation. Mr. Peraza, you're on probation out of Miami-Dade County, correct?
Yes.
Okay. So there's certainly probable cause on some of the charges. Now, there may be some search issues to deal with later. That'll be something for Judge Garcia to decide. I agree with Mr. McDaniel that the lighter is a non-factor. The wrapping papers would be a non-factor if it wasn't for the presence of the alleged marijuana. But when you've got marijuana and wrapping papers, I think that's enough, at least for probable cause. I don't think the lighter really helps the state's case. The lighter how many people have a lighter in their vehicle for one reason or another? So I'm not persuaded at all by that. So I'm going to find probable cause on the bringing unauthorized Schedule I controlled substance. Your bond on that's going to be $15,000. Possession of marijuana has probable cause. That bond will be $10,000. It's possession over 20, excuse me. Paraphernalia has probable cause. It'll be $5,000. On the driving while license suspended first offense, there's probable cause $5,000. I know that you have a prior according to your driving record, but the officer doesn't allege that in the complaint. So I've got 15, 10, 5, and 5. That adds up to $35,000. Don't try to post it, though. The reason I'm telling you don't try to post it is 2 reasons. Number one, you've got a Bay County warrant, I believe. I'm asking the jail to look into that, and it's for one of the same offenses you're charged with now, and it's a new warrant. It's a 26 case number. And number two, I'm going to hold you for 7 days. I'm going to ask Mr. Mitchell to notify the authorities or the probation office. He appears he's on probation out of Miami-Dade County in case 25 16153 for multiple counts.
Can you say that again?
25-16-15-3.
CF.
I think they're supervising out of Bay County, but your sentence was in Miami-Dade. So Mr. Peraza, I want to see you in 7 days. We'll see if they have a warrant. Miami-Dade County is such a huge county. They may not have a warrant within 7 days. And if they don't, I'm going to release that warrant, that hold on you. But you still got to deal with Bay County to see if they have a warrant. And you can decide. I would suggest you wait and see about other holds before you try to post a bond, because you're not going to get out even if you post a bond, and you need to know if Miami-Dade County is going to issue a warrant, number one. And number two, is there going to be a bond on the warrant? You do have a condition of random urinalysis on the Jackson County bond. So, Mr. Peraza, I'm going to see you next. Actually, let me do this. I want to see him because it's such a confusing case. I don't want to burden a covering judge with this. I'm going to see him Monday instead of Tuesday. So it's actually going to be a 6-day hold because I'll be here Monday. I'll see you next Monday, Mr. Peraza. We'll see if we have any warrants anywhere else and go from there. Any questions?
As far as my marijuana license, the possession.
Just deal with that later. Okay.
Yeah, talk to your attorney about that, because a marijuana card allows you to possess marijuana only in certain situations, certain packaging. It never can be a loose cigarette, which is what you allegedly had. So there's some possible defenses or partial defenses you need to talk to an attorney in private about, okay?
Okay.
Have a good day, sir.
Did you give him his court date?
I'm sorry?
Did you give him his court date?
No, remind me next week. We'll give it to him then. We have Thomas Tyndall. Mr. Tyndall, good morning. Mr. Tyndall, I also have William Blackburn. So, Mr. Tyndall, you're on a failure to appear warrant. You've already been arraigned. I don't have to arraign you. You've got no bond. You're going to be in court on August 6th to see Judge Garcia on the violation of probation allegation. Any questions, Mr. Tyndall?
No.
All right. Wish you the best, sir. Mr. Blackburn, you're also accused of violation of state probation, but you have not been arraigned. It doesn't appear. There's a no bond warrant signed by Judge Garcia. Mr. Blackburn, I want to go ahead and arraign you this morning because I want to get you a lawyer appointed if that's what you're asking for. Would you like to have an attorney appointed to represent you, Mr. Blackburn?
Yes.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel. I'll see if you have any questions in just a minute.
No, we're really going to plead not guilty. Yes, to set this in August 6th court docket, and advising the attorney come back speak to him prior to that hearing.
Mr. Mitchell.
Nothing from the state, Your Honor.
Mr. Blackburn, any questions?
No, sir.
All right, sir. Attorney will see you before your court date. Have a good day. We have Zachary Dixon next. Mr. Dixon, good morning. Mr. Dixon, you're here because you've been accused of one count of burglary of a dwelling or structure with more than 1,000 damage to the structure, and also been accused of a misdemeanor. Mr. Dixon, there is probable cause in the complaint. Look at your criminal history. It looks like you've been to prison 4 times, got out most recently in April of 25. Mr. Dixon, I'm going to listen to the attorneys and I'm going to set your bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell.
Nothing from the state, Your Honor.
Mr. Dixon, this is a first-degree felony punishable by life based upon your criminal history. Your bond's going to be $100,000, sir, cash or surety, with a condition of no contact with the alleged victim. $5,000 on the misdemeanor, so your total bond's $105,000, Mr. Dixon, because of your criminal history and the damage you allegedly caused to this business. Mr. Dixon, your court date will be August 4th. The jail will give you a notice for that date, sir, and you'll get to use the phone in just a few minutes to try to post the bond. Do you have any questions?
Yes, sir. Thank you.
Yes, sir. I wish you the best. After Mr. Dixon, we have Isaac Noss. Mr. Noss, good morning. You're here accused of one count of trafficking methamphetamine of 200 grams or more. And I spent probably 20 minutes trying to figure out what happened in your case. The best I can tell, Mr. Mitchell sent an email that kind of helped us. The best I can tell is the guy first appeared in another county. But I can't tell. Was he first? Go ahead, Mr.
Mistake was made before. It was arrest warrant for him in Jackson County for the warrant. They arrested him in Washington County and sent the paperwork over to Washington County, and they first appeared him and gave $150,000 bond. Jay, because that's my understanding.
Yeah, pretty much, even though it wasn't a Washington County case, it was supposed to be the Jackson County case.
But there was no warrant. It was just a PC arrest, right?
Yeah,
okay.
That's what it was.
So there is probable cause, Mr. Noss, in the complaint for a crime occurring in Jackson County. There is no probable cause for a crime occurring in Washington County. So I have no problem just setting the same bond here. But my question is, The bond in Washington County, Mr. Mitchell, what happens with that case? Is there a case in Washington County?
There is no case in Washington County. That one, I've been told that one's going to go away. There was a Nebia hold that was actually filed in that one, but given the fact that cases go away, I refiled a Nebia hold in this one for Jackson County.
So, Lieutenant, do you show a hold or detainer from Washington County?
No, sir.
Okay. So, Mr. Noss, your bond is going to be the same $150,000 you've had, except it's now Jackson County. There does not appear to be a detainer from Washington County, and I see no evidence of a crime committed in Washington County. However, the state of Florida has filed a Nebia motion, which essentially means that they're asking for evidence of the proof of where the bond comes from before you're allowed to post bond. So you're going to be held until you can, if you decide to post bond, you would contact the jail that you've got the ability to post bond. The jail would immediately notify the public defender's office, and that motion will be heard before myself or Judge Garcia to show the source of the funds of the bond. Once the source of the funds of the bond is verified, then you certainly will be allowed to post bond. You just got to prove the source of the funds of the bond. Your bond's $150,000 with a condition of random year analysis. Your next court date will be August 4th at 1:30. Mr. Noss, do you have any questions?
No.
Have a good day, sir. Jennifer Hartzell. Ms. Hartzell, good morning. You're here because you have a hold out of Bay County. I took a look at the cases down there to try to make sure there was no warrants on the bond. I couldn't see any warrant, ma'am, so I couldn't see a bond. So you're going to be held for Bay County, Ms. Hartzell. You'll be down there hopefully in the next couple of days. When you get there, you'll go to another first appearance, and that local judge will decide if you're entitled to a bond on these charges or not. Do you have any questions? Have a good day, man. Michael Robinson. Mr. Robinson, good morning. Mr. Robinson, you have a local charge of violation of county probation in 23224 MM. In addition to that, you have a holdout of Sarasota County and a holdout of Orange County. I'm appointing the public defender's office to represent you in the Jackson County case. Please listen to Mr. McDaniel.
Your Honor, I've talked to Mr. Robinson. You know, I don't know if Tim is in there, but Tim was his probation officer and he's been communicating with Tim, and he come and turned himself in after talking with Mr. Ham. And Mr. Ham advised him to bring his verification of his drug rehabs classes, and he brought all them that go back to 2023 to early 2024. You know, and I didn't know if the court was going to, you know, want to take any of that stuff into consideration or talk to Mr. Ham.
Yeah, this is the first I've heard of this. Is Mr. Ham here today? Yeah, that's the first I've heard of this. So let me do this because we have several more and because we've already had quite a few. You've got no bond, Mr. Robinson. I'm going to see you again tomorrow. What that'll do is it'll give. I'll see you again Thursday. What that'll do, Mr. Robinson, you've got holds other places anyway. So I want to look at whatever evidence your attorney wants me to consider. But there's been a warrant out for you since 2004. Excuse me, 2024. It's been a warrant out for you for almost 2.5 years. So I've got some questions, and I'm glad to listen to you. But we're gonna see you again in 2 days. That way, Mr. Ham can be up here. We can find out more about it. You're not going anywhere. You're wanted in 3 counties in Florida: Jackson County, Sarasota County, and Orange County. So you shouldn't be surprised. You're not going anywhere. Do you have any questions about what we're doing today?
Yes, sir. So Sarasota County was because I was getting my truck worked on. They gave me a loaner car, and I was out of town. They told me I had to return the loaner car that day because they were trying to sell it. I told them to send people over to tow the car. They sent cops over to tow the car, and I talked to the cops and everything. I didn't know I had a warrant for that. This paperwork that I have right here, I've been had the AA meetings done. I don't know why I didn't turn them in. I've been had the AA meetings done, and I can pay the $80 that I have left for the supervision. But the reason why I try to turn myself in today is because I'm trying to continue my career, sir. I do health and life insurance, and I try to renew my license in the state of Georgia and in Illinois, but they won't let me because this came up. So I can fix this. I have this done, and I can pay the $80. The meetings been done 2 years ago. The meetings were done before I got violated, but Mr. Ham told me I couldn't electronically send them to him, and I had to turn them in. And as far as I forgot what county you said, but that was because they gave me a loaner car because they was working on my car, and I couldn't take it. So they came to tow it, and they had a cop to come out, and they didn't arrest me. So I don't know how I even have a warrant for that.
Mr. Robinson, you have a warrant out of Orange County for battery that has no bond on it. You have a warrant out of Sarasota County for failure to return leased property. That's what you're talking about. And you'll
Yes,
get a
sir.
bond once you get there. You're not getting out of jail today, period. I will see you the day after tomorrow, and that'll give us time to look at any defenses you have to this violation of county probation charge. If we need to set it for a hearing after that, we certainly can do that. But I haven't seen the documents, and Mr. Ham isn't up here today to tell us more information. So I will see you the day after tomorrow. You've got no bond for 3 counties, not one, for 3 counties. And we'll see you in 2 days. Do you have any questions?
You're not gonna get out no way. I mean, it's something.
What's that Sarasota case number?
Sarasota case number is 25. No, it's just an agency number. I don't have a clerk number.
Okay.
25-69913 is the agency number. That's the failure to return leased property. Next case we have is, I believe, it's Lewis Phillips. Is Mr. Phillips the last case? So Mr. Phillips, good morning. Mr. Phillips, you entered a plea to the charge of driving license suspended. I think that the offer was 60 days in jail. I cannot remember if that was a state offer or if it was a judge recommended offer.
I think it was you.
Yes, it was from the first appearance, a tentative offer then. So Mr. Phillips, you told us yesterday about some employment. I think Mr. Goodson checked on that. And listen to Mr. Goodson. He's going to tell us what your employer said when he tried to verify your employment. Okay.
Yes, sir.
Judge, I called after first appearances yesterday. I called T4 Steel. I spoke to his supervisor, the owner of T4 Steel. Mr. Phillips, help me with his name. Was it Givens?
Travis.
Sir?
Travis, the owner of the company. Yes, sir.
Yes, sir. I spoke to Travis, and I told Travis the situation involving Mr. Phillips. I explained to him that you had previously offered him 60 days in jail, that you might consider offering him probation if he had employment. That's your decision. Anyways, he does have employment. His employer said he's a good employee. He wants you, if you were to get probation today, he wants you to come to work immediately when you leave the courthouse. So he does have a job. He will have a job, and he's a good employee according to his supervisor.
Yes, sir.
Thank you, Mr. Goodson. Mr. McDaniel, anything you want to add?
No, Your Honor.
Mr. Mitchell.
We're not opposed to sentencing him to a year of probation. I believe this is his second or third DWLSR, so it would be the year.
They're older ones. So, Mr. Phillips, I don't necessarily mind giving you a shot at probation when a man or woman's working. I always take that into account. What you need to understand is this recommended disposition that was tentative offer made to you was 60 days in jail. If you want to take the 60 days and you want to do it, that's okay. You get credit for what you've done. You get out. And you put this all behind you. If you want to do probation and you make the probation, that's great too. Good for you. I hope you do. If you choose it. If you take the probation and you get caught driving or commit another crime, or you violate the probation in a substantial way, such as not reporting, anything like that, then you're going to wish you had taken the 60 days because there's a high likelihood I'm going to sentence you to more than that.
Yes,
I want you to do what you think is best, and I hope if you take probation, I want you to make it, but you need to understand there's consequences if you don't. So you need to make sure that you're committed to do this probation if you decide to do that.
Yes,
so
sir.
Knowing all of that, do you have any questions?
No, sir, but I just wanted to say I'm committed because I got a family to take care of. I have grandkids and I have a pretty good job. It pays pretty well. So I want to try and keep that.
Well, it says something about you that they want you after being in jail for 2 or 3 days and missing work. If I'm late from lunch, they want to fire me. So I appreciate you being a good employee, and that's one of the reasons I'm willing to do this. I've already accepted your plea. I think I accepted it yesterday.
You did.
So I've already accepted your plea. I'm going to withhold adjudication of guilt and sentence you to 11 months and 29 days probation. You'll have the standard conditions of every probation. In addition to those, Mr. Phillips, you'll have a condition not to drive a motor vehicle unless you get a valid license. If you get a valid license, you drive all you want. But if you don't have a valid license and you get caught driving, that's going to violate your probation. You're also going to have a condition that you pay the standard court costs and fines. They're $400. What's going to happen next is they're going to let you get dressed at the jail. They're going to let you use the phone if you need to for transportation. Then they're going to bring you to the courthouse. The reason for that is the courthouse is where the probation office is at. When you get here, you'll meet with the probation officer. They will explain to you the probation, give you a chance to ask questions, give you all the rules in writing, and you'll be free to go. And as Mr. Goodson says, your employer wants you back at work today, if at all possible.
Yes,
Do you have
sir.
any questions? Do you have any questions?
No, sir, I don't have any questions. But the only thing is I get off at 4 o'clock and I don't know how long it's gonna take me to go through this process to the courthouse.
You'll be there about 11.
Okay.
You'll be at the courthouse probably within 30 minutes or so.
Okay, thank you.
Okay.
There is a condition to obtain a license if legally eligible.
Thank you. I forgot one condition. There's one other condition that I always impose, and that is you'll obtain a driver's license if one is reasonably available to you. What that means is some people have to pay thousands of dollars and simply can't do it to get a license. Other people just have to pay a single ticket. If you can reasonably get a license, you'll be expected to get one. Your probation officer will require that of you, okay?
Yes, sir.
All right. Have a good day, sir.
Yes, sir.
Mr. McDaniel, I know we got some scheduling things to talk about, but other than that, anything else from the public defender's office this morning?
All right, that will do it for Wade Mercer this morning. Good morning once again, everybody. Hour 2 of TCF Live. Tim, earlier you gifted 5 memberships. Thank you for that. I appreciate it very much. Let's go to Texas. Judge Stevens.
26 CR7 67 is now called the state of Texas versus Melzaneira Henderson. That is you. Yes, that's yes. Yeah, she's got to take everything down, and that could be or you know. So yes, no. Work with us on that. All right, you've been indicted here in April for the 3rd-degree felony of collision involving serious bodily injury. I was on or about January 11th, which states in summary that you intentionally or knowingly drove a vehicle that became involved in an accident resulting in serious bodily injury to another person. And then you left the scene of that accident without giving your name, address, registration, things you're supposed to do by law, and without rendering reasonable assistance. This is treated as a very serious offense. You are looking at up to 10 years in prison for this. And there's a good reason, because even in a collision where you're not at fault, you still have a duty to stop and help others involved in the car accident. And that's just plain decency, because that happens too often here in this courtroom. People are involved in a wreck and then they take off for whatever reason. And the other person, we had a case not long ago where the person was killed. And there was a lot of weeping and crying, and the jury didn't take long to find the person guilty in the trial for not being humanitarian. You got to help others, even when it's not your fault. You have to help others. So Mr. Dusler is here, going to help you. And what are we going to do today?
She and I are just now discussing the case. If you can let us hold for announcement. We're either going to just do something today, or we'll reset for a short period of time.
Okay, let me know, Don.
Yes, sir.
Thank you.
Thank you.
Michael, is it Follett? I know I'm pronouncing that.
Judge, I was told that he's already hired Dustin Galmore, and the representation's already there.
Really?
Yes, I think
I don't see a file here.
Well,
so
because
I guess y'all
I think it's
pulled
already been reset.
Yes, sir.
Did y'all pull it?
Yes, sir.
James Frizzell, Tom Kelly. Are you Mr. Frizzell?
Yes, sir.
Have you seen Mr. Kelly?
I have not.
Okay, we'll try to look for him.
Okay.
Roderick Weatherly, are you here? That's you, and you're another Tom Kelly.
Sir,
Tom Kelly is your lawyer as well, right?
well, I had Mr. Westhead first. I came the last time.
You're Roderick Austin Weatherly?
No, sir.
Okay.
I'm about to say Frederick.
Okay, where's Roderick Weatherly? No answer? I ask the bailiff to call into the hall for Roderick Weatherly in 25 CR 865.
If I can get, Kelly.
Are you Roderick Weatherly?
Yes, sir.
Everything's happening in here. I'm not gonna go outside. This is where the action is. You have to be here at 9 o'clock or else your bond, you could lose your bond.
Yes, sir, but I was here. I'm sorry to interrupt.
Would you have to be here in the courtroom? That's where the business is conducted, sir, not out in the hallway. Okay. And is Tom Kelly still your lawyer?
Yes, sir, he still is, but he's not present.
He's not yet. He should be here. Just have a seat and we'll wait for him, okay? All right. David Graham. David Graham? Once, twice? No David Graham in 25 CR 1177. I asked the bailiff to call into the hall for David Graham.
David Graham? David Graham?
Was Brent Turks?
You know, discussed it earlier, Jeff.
We must, the other guy must be here.
No response, Your Honor.
David Graham, no response. There's no answer to the name called here in the courtroom, no answer to the name called in the hall. Defendant has failed to appear. I'm going to ask our fine coordinator, what is his bond, please? Thank you. Thinking 6,000, something like that. $6,500.
It is 6,500.
6,500. Okay, again, David J. Graham, no answer. Defendant has failed to appear. A warrant shall be issued for his arrest. His bond in the amount of $6,500 has been revoked. It is doubled to $13,000. And now he must have a GPS device. And so we know where he is when he's not in court. He's in home confinement and he can go to and from in the most direct route possible. Medical care, food needs, to speak with his attorney, to come to court. Those are the orders of the court. And the warrant shall be issued. Harley Davidson. I just want to say that. Harley Harrington. That's you?
Yes.
Okay. And Mr. Kirk is your attorney, right?
Yes.
Okay. Oh, we set that up. You were charged here in 26 CR 510 with the third degree felony of tampering or fabricating with physical evidence. Unlawfully carrying of a weapon, intentionally only concealed a weapon, and there's a Glock. And if convicted, this is a third degree felony. And you are facing no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Does the defendant have any prior criminal history? No?
Not to my aware of, Judge. We have an offer. She's
Fix this. This is fixable. Yeah, you just make a mistake. Okay. Welcome. We all make mistakes. Fix it and move on with your life and do better. What else? April 1st. Those indicted. Couldn't have been typed with any smaller print. There is no way that.
I understand.
Don't challenge them, Judge. They'll find a way.
Get this computer Zoom. Any chance?
Yeah.
Mike's been an offer. She just wants to come out the video. That's all she wants to do.
Well, correct. That's facts.
There's a unique aspect of this. The disabled driver. Which is unique.
You don't see this often. Normally, people just don't toss handguns out their vehicle. They normally keep them. You're gonna do that, you don't want to do it when a policeman is right behind you, watching them. She was arrested for public intoxication as well, is that right?
That's right, yes.
Okay.
I think that's accurate, Judge.
That's public intoxication or intoxication isn't voluntary intoxication is not considered a defense in the laws of the state of Texas. So can't say, well, I didn't know what I was doing because I was intoxicated. If it's voluntary intoxication, it's your fault. You got to take responsibility. So today, what do we set for announcement?
Yes, sir. She wants to watch the video. I think we're going to be able to resolve this one, but she wants to watch the video and go with discovery judge.
Okay. I got 4 weeks. Is that good? Thanks. Good set.
Alrighty, friends, we'll keep an eye on Judge Stevens, but let's march across the hallway and say good morning to Judge West.
Yes. Good morning. Are you Travis Smith? And Mr. Smith was previously in court, entered a plea of guilty to theft of property with previous convictions. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
I've read it, John.
I have, Judge. Are there any additions or corrections?
No, well, one thing is it's an addition, and I just found out about it Friday. In the report, it says his mother abandoned him at 3, which is true. But she's now straightened herself out, and she's helping run a rehab center in Lafayette, and it's going to become part of his life. He's got 2 uncles here, so he has. They're in the courtroom. He has strong family support.
Okay.
A lot stronger than what that says.
Good, thank you. I am also going to take judicial notice of the court's file. Mr. Smith was previously found not competent and was sent to the John Dunn Behavioral Science Center and restored competency. Any issues right now before sentencing with competency?
No, I think have you been taking your medicine in jail?
Okay.
I don't think so, Your Honor.
Okay,
But I'd have to be a psychiatrist to truthfully answer it, correctly answer it.
All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but that will be probated for 5 years. So you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That is going to include being on the mental health caseload so that you can get whatever help you need. Follow all of those recommendations, meetings, medication, whatever. That's all part of your probation now. You do all of that. This is a great opportunity for you to get your life back on track. And you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yeah.
I'm handing you two things. One is the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams.
Judge's misdemeanor will be dismissed.
Yeah,
Okay,
that's what I
thank
was
you.
just
All
saying.
right, so
You're
those to get that misdemeanor dismissed as well as part of that this morning. Okay, good luck to you.
Thank you, Honor. He be released today.
He should be, yeah, as long as there's no other hold that misdemeanor, once it's, if there's nothing else in the other county. But if it's just this, yeah, you should be released today, and you'll get some instructions today before you leave the courtroom from probation to tell you exactly what to do when you're released, okay? Okay.
Thank you, Honor.
Yes, sir. Ms. Delays, you have Jeremy Alexander.
Yes, Your Honor. What's up?
Good morning.
Good morning. Rainy morning.
Yeah.
That was a lot of.
Very rainy, a lot. Morning. Good morning, sir. You Jermaine Alexander? And this is 26 DCCR 0178. Mr. Alexander is charged with injury to a child, elderly or disabled individual. And what is the announcement?
Your Honor, we're going to ask for some more time. I'm still waiting for some discovery. I have not gotten any of the videos yet. Did talk to Mr. Smith about that. We're thinking they might be online, but they weren't given to me yet. So I'm going to double check.
Okay. So if y'all will both check on that. And so Mr. Alexander, I'm going to reset your case so that Ms. DeLage can get all of the videos and everything that the state has. And she'll be able to be out there hopefully before that next court date to go over all of that with you, show you everything. And then we can get an announcement at the next court date. Okay, you go back with the bailiff.
Just
thank you. Thank you, ma'am. I could just put a notation. Videos specifically. Yeah. Brian McWade and Mr. Macon.
Good morning, Your Honor.
Good morning.
All right.
Yeah. Good morning, sir. You Brian McWade? Yes, ma'am. And this is cause number 26 DCCR 0402. Mr. McWade is charged with aggravated assault with a deadly weapon. Mr. Macon has filed a motion asking that I set a reasonable bond. What is the bond currently?
$500,000. It was time.
Were we here already on a bond?
That was the first motion I filed to try and lower the bond, and we denied it.
This is April.
Right.
April
I usually
22nd.
I usually don't do this twice.
Oh, okay.
Unless something, significant has changed, if there's some new evidence. Other than that, it's just a matter of if the case is going to go to trial, then there can be a rejection and we can get it set as quickly as possible. But unless there's new evidence with regard to a bond, I'm not going to hear the same evidence again. The fact that he's still in custody isn't necessarily new evidence.
He has a job waiting for him with Utah, right? As an electrician.
Okay. Ms. Malfino, does the state have?
I apologize. This was formerly a 5A case, and I don't know if maybe it got
get back along rather quickly and it was not on our docket. If you could give me a few minutes, I'll either go get it. I would appreciate the opportunity to at least review it. Its court has already heard this. I'm sure my position will be the same as Mr. Coleman's original one.
Yeah, and it shows on my docket that it's Mr. Nichols. Is that not correct?
It may be, Judge. I think it was an add-on. I didn't have it on my docket, didn't have it pulled for this morning. But we'll get it good.
Okay, well, it's on the regular docket, so it wasn't added on too late, but maybe it was a week or so. Let me hold it for a minute. Just go back with the bailiff.
Some of that is the numbers changing in
Right.
the computer. They print out different numbers. Take a minute.
Mr. LeBlanc, looks like you're working on, are you working on Derek Shinkle? Okay, I'll hold it. Mr. Rojas, you have Vicente Gloria.
Hold
Hold on a second.
I'm gonna ask for a reset. I'm trying to run out some more information.
Okay, we're gonna reset Vicente. We'll reset Vicente Gloria. John Hill.
John Hill.
Good morning, good morning.
Good morning. Good morning, Your Honor.
Good morning, sir. Are you John Hill? And let me get this pulled up correctly. Mr. Rojas, will your client waive a formal reading of the motion?
He will, Your Honor.
Mr. Hill, in clause number 22-40932, I have an amended motion to revoke your unadjudicated probation. Shows that you were placed on probation March 28th of 2023 for the third-degree felony offense of forgery of a financial instrument. Is it a third? The docket for some reason has state jail beside it.
It looks like it's a third, Your Honor, on the motion, on the admin.
Okay. I just want to make sure I'm saying the right thing because it has SJ on the docket.
It was enhanced, Your Honor.
Okay, so it was a state jail felony forgery that was enhanced to a third degree.
Yes, Your Honor.
And it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of theft of property less between $100 and $750, April 15th of 2026. Is that true or not true? True or not true?
Judge, we can drop count 2. It's duplicative. It's injurious habit. We're committing theft. I'm sorry. We're going to drop count 2 just because it's duplicative.
Count 3 alleges that you're behind in your court assessed fees as of April 16th of 2026 in the amount of $10,859. Is that true or not true?
True.
Count 4 alleges that you failed to report as directed to the probation department for the months of April and May of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas, and that you were in Orange County June 1st of 2026 where without permission. Is that true or not true? True. And then count 6 alleges that you failed to immediately report the arrest for theft of property to your probation officer. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
Give me just a second. I need to look back at some things to understand. Looking for the PSI. Also.
Was your question about the 3R?
It's actually a third degree. It wasn't enhanced. It was not
Okay.
enhanced. It was a third degree forgery. That was amended back when he entered that plea in March to show that it was just the caption that was incorrect. Okay. Got it. What is the status of the new theft case?
It's pending, Judge. When this is over, we're gonna take him down the hall and give him plea to that one as well. I believe it's set this morning also.
I realize most of this history is very old. I just don't know that I love a 45-day sanction for someone with this kind of history for the same type of, I mean, it's a theft.
And Judge, if I can, the thing that he was stealing food, it's not like he was out stealing stuff to go, alcohol or anything like that. He and his son have started a trucking company. He is going to be gainfully employed when he's released. And I think, as far as I know, the court's not really concerned about the money, but he did have an accident which made it hard for him to stay up to date on probation fees. And he's trying to turn his life around, Judge. I think he's, like I said, he started the trucking company. That's a step in the right direction, I think.
All right, so Mr. Hill, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement is for me to continue you on probation, but order a 45-day sanction as a condition, and with the, I guess, the caveat that you're going to go take care of the other case. There's going to actually be a plea. It's not getting dismissed, correct?
That's correct, Your Honor.
Is that your understanding?
Yes.
Obviously you can tell I don't love this agreement. I want to make sure you understand if I follow this agreement and you're in trouble and you're in here again on another motion, it's not going to go this way. Okay.
I'm embarrassed.
All right. I'm going to, state tenders number 1.
No objections.
It's admitted any evidence that Mr. Hill's not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order that 45-day sanction. And you will get, agreement is for him to get credit since the motion, right? The arrest on the motion.
Yes, Your Honor.
So you will get credit on that 45 days for any amount of time that you've been in since you were arrested on the motion to revoke. So not from the original part of the case, but just since you've been in on this. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you have waived your right to appeal. Take advantage of this today. All right. Good luck to you, sir.
Thank you, Your Honor.
You can go back with the bailiff.
Yes, ma'am.
Alrighty, friends, it's TCF Live on a Tuesday. Just about to close out hour number 2. As always, time flies. Let's change it up a little bit, head a little bit east over to Louisiana. Let's check in with the board.
The Louisiana Committee on Parole is impaneled at headquarters in Baton Rouge. On the panel today, to my left is Carolyn Stapleton. To my right, Danny Bobroff. I'm Jerry Ledoux. We have before us at the Iberia Parish Jail, Mr. Francisco. Could you introduce yourself with your name and your DOC number?
James Francisco, 525235.
Okay. Is there any staff in the room with you today?
Yes, ma'am.
Would staff please introduce yourself for the record?
Deputy M. Joseph.
Thank you very much. Deputy, have you had any problems with this offender since he's been in custody with you?
No, ma'am.
Thank you.
You're welcome.
We also have Mr. Richard Spears, who is the attorney of record. Mr. Spears, would you introduce yourself?
Yes, ma'am. Richard Spears of New Iberia, Louisiana. I represent Mr. Francisco.
Okay. And we also have two other people, but what we're going to do, first of all, I need to read out for the record the allegations against Mr. Francisco, and I need him to enter a plea of guilty with a statement, or not guilty. You may assist him if you need, but I need him to enter the plea.
Yes, ma'am.
Sir?
I said, yes, ma'am.
Okay. I'll read those and then you can give the plea. On or about March 23rd, 26th, you failed to refrain from criminal activity when you were arrested on April 7, 2026 by New Iberia Police Department. You were charged with home invasion. According to the clerk, home invasion was actually null-prossed on May 28th, 2026. How do you plead to that?
Not guilty.
And number 10, you failed to make any payments towards the your fees, resulting in being $756 in arrears. How do you plead to that?
My fees are all paid up.
Okay, so since you've been remanded, you've paid your fees?
Yes, ma'am. I couldn't work at the beginning when I first got out due to the case that I was going on. I got burned, so I couldn't really work. But everything's been settled.
As of today, your fees are paid?
Yes, ma'am.
Okay, thank you. Hey, Mr. Francisco, we have Leah Orson, and throughout the reports, I'm confused because she's referred to as wife and girlfriend. So what is the legal relationship between you and Leah?
She's my girlfriend and also my daughter, mom.
Okay. And you also have William Orson in support today. Would you like to have them speak first?
Yes.
Okay. So, Ms. Orson, if you will speak to the panel, give us some information about the occurrence that we're discussing.
Yes, I called him to come get me because I no longer wanted to be there because me and my cousin had got into it, and I just asked him to come get me, and when he showed up, it was just a whole bunch of stuff going on.
I will just say that the police report and the letter of recant are so wildly different that I just don't even know how to process that.
Yes, ma'am. They lied. Like he didn't break in the house. The police report is all wrong. And my aunt, she even told me that he didn't break in the house. He didn't push her. So she's not understanding why that's on the report as well. She told me personally she never said that. And so they signed affidavits and now the charges were dropped. The case was dismissed.
Mr. Orson available and wants to make a statement.
Yes, ma'am. William Orson.
What would you like to say?
I would like to say that all he did was come over there to get his little baby daughter and my daughter. And he didn't kick the door in. He didn't force his way in. He just knocked on the door. My daughter opened it. My sister opened the door for him, and he walked in the house and proceeded to get his child.
Were you there?
Yes, I was.
Okay. Okay. Miss, so with the attorney, sorry. Mr. Spears, would you like to make a statement on behalf of your client?
Yes, ma'am, I would. Thank you very much. So I represent Mr. Francisco with respect to the home invasion charge that was null pros. I don't know what everyone's orientation is, but I'm going to ask this: does everyone know what a Gwen's Law hearing is?
Yes.
Yes. Okay. So there was a Gwen's Law hearing that took place shortly after this happened. I represented him at that hearing. There was some testimony, and the DA did some research. And Mr. Sanji, who was the assistant district attorney, called me and said, "Look, I'm going to drop it. See if you can get somebody, get the victims to write something saying that they're okay with dropping it." But this was not dropped because the victims initiated it. This was dropped because Mr. Sanji, after the Gwen's Law hearing, did not think that that he was going to be able to prove his case. And so the victim stuff that was put into the record after was simply something that the DA likes to have done to clean everything up. But this case was not believed at the very beginning by the prosecutors. And I know that his decision doesn't bind you all in any way, but that was my observation of, and what he told me is that he thought that it was not a credible allegation.
There's a difference between having enough evidence to prosecute someone and the fact that it didn't happen. I mean, that.
Well, the difference, I would just say that the difference between having to prove it beyond a reasonable doubt and you know, what's written in the affidavit is one thing. For the DA to decide that that they're not even interested in billing the case or further investigating it or seeking out any victims tells me that that the district attorney's you know, take on this thing is that it just completely wasn't credible.
So the police report was not credible.
Not that the police weren't credible, but that the statements given to the police that day were not believable.
Okay. Ms. Stapleton, do you have some questions?
Yeah, I do. So later, an officer for the New Iberia Police Department, she writes a letter that the victims, this is after everything, I guess, settled down, and she writes a letter, let's see, on March 25th, that victims of the child's mother, the family, that they had been getting threats from him and that they were fearful of him. So here's the thing about some things like this sometimes. It really happens. And then later, I mean, they tell the police, you know, in the heat of the moment, they tell them what happened. Then later, sometimes threats do come their way. And then we have recants. But I mean, what they said happened, that he came there getting the child and throwing the child in the back of the car and all of that different thing, an infant, that was very horrific.
If it occurred, yes, ma'am.
Yeah. So the fact that we have these recants, but we also have a New Iberia police officer that said that she was getting reports from the family that he was making threats against them. So people do recant under those situations.
I can't speak to that, except that I can say the district attorney also had that information in his file when he made his decision.
Yeah, I know, and I do know that they a lot of times don't go forward with it.
And ma'am, I'll also say that down here in my district, in the 16th JDC, domestic abuse situations and things like this are taken extremely seriously. They do not typically jettison a case simply because there's a conflict in what people said, or because the victim recants or asks to drop it.
Well, I know that to be true. I know that they take victims very serious in your area. I do know that to be true. Let me ask, Mr. Francisco, why don't you tell me what you have, your version?
I was working on my truck and Lil called me. So I stopped doing what I was doing, went in the house, washed my hands up and everything, and I went over there, I knocked at the door and get answered. She said, Lil, she said, hey brother, because they call brother, you know, I grew up since I was a kid. And she said, Lil, James is here, you know, so she stepped back, I walk in, Lil handed me the baby in the living room. And as she handed me the baby, she reaching to get the diaper bags and whatnot. Well, as I turned to walk out with her, the cousin Chloe started swinging on me. She swinging on me.
Who started swinging?
She started swinging on me the whole time with my baby in my arm. All the way until they got videos. They even gave the videos to the officers and whatnot, but all the way to my car, I never picked up my hand, nothing, holding my baby, and I turned aside. You know, and I got in the driver's seat of my car, and Lil got in the passenger seat of the car. We left, you know, and I gave the baby to Lil down the road. So, and that's all on video. So with them saying I threw a 2-month-old baby in the back seat, you got to be sane to do something like that. Really? That was a lie. We left from there and we went home. And the reason all this else occurred, you know, I ended up talking to Megan's husband, you know, and like, James, I know they're lying on you, don't worry about anything, you know, and whatnot. So by this time, my father-in-law, he finds out that they call the cops. So he goes to the police station and let them know that they're lying on him. You know, the police officer told me, I think her name is Davis or whatever her name is. She said, oh, well, he got a record. She said, we've been dealing with him. The best thing for him to do is himself in and fight it from court. You know, and I understand I got a record, you know, but, you know, they don't believe people can change. And that's my fault, you know, because of my stupidity back in the day when I was young. You know, so, but I paid dues to society on stuff that I did in the past. But what they're saying, they're really lying on me. You know, and I can't sit here and say, oh, well, this is that, you know, and they have all this stuff from my past history from a kid coming up. You know what I mean? So I can't really follow them. We'll have to come to jail and prove my innocence in court. Whether, you know, they're sitting there lying or whatnot, who words are going to take, mine or theirs. You know, as a convicted felon.
They saw who was taking video. Was somebody had their phone and taking video of all this? I hadn't seen the video.
They had video from the house, which was given to my parole officer. So she seen
video inside the house when all this. I mean, did they have a video camera inside their house?
The video was coming from the house all the way till I got in the car. So the video showed me literally getting in the driver's seat with my baby, and Lil got in the passenger side. What they said that I threw the baby in the back seat, driver's side, and Lil got on the driver's seat, which is a lie. So how can she get in the passenger seat and the back seat at the same time?
Now, this is what I see in the report, that he tossed the infant in the back seat of the vehicle without any type of child restraint, and then got into the driver's seat of the vehicle. While in the driveway, Leah and Chloe and Caitlin attempted to stop the parolee from leaving with the infant. Parolee, James Francisco, continued to yell at them and threatened to return to the residence and kill the whole family. Then Leah was able to open the rear driver door and enter the vehicle in an attempt, this says, to retrieve the infant from the vehicle. Parolee Francisco was able to drive away from the residence with Leah and the infant inside the vehicle. But you said there's a video that disputes all of this.
Yes, ma'am.
No mention of the video is made here.
That she literally got in the seat. I got in the driver's seat holding my baby. Yeah, I didn't, I should have her in our seat, but Chloe swinging the whole time. I made it to the driver's side and got inside the driver's seat. While I was getting there, you can still see her swinging over the top. At one point, she grabbed my baby by the arm, and that's when Leah hollered. She's like, stop, he got my baby in his arm, stop. She's telling Chloe that.
I see. Let me ask you, at the hearing for Winslow, did they approve a protective order or not? Was that, I didn't see that.
It was nothing protected order.
Okay. I mean, the attorney, you would know that too, sir. Was
yes, ma'am. Off the top of my head, I do not remember one being issued.
I didn't see it, so that's why I was wondering about that. She just talked to us and said that none of this happened that way.
How many children do you have?
I have 11.
Okay, because I read 14 in one place in your record and 16 in another.
How many is it?
You have 11.
The stepkids. They have the stepkids too. I mean, her kids, I consider them as mine.
Okay, on 2/9/26, what date did this happen?
3/23, maybe. That's when. Yeah, 3/23.
Agent Seth Como said that he contacted the offender. The officer informed both the offender and the girlfriend that there are consequences for lying, and the offender could get in trouble next time they continued to lie. They both stated they understood. So he would come to check, and she would say, "Oh, he's not here," and yet you were there. So there's a history of not being truthful to the agent that we have in the record. I'm personally having a very difficult time reconciling what really happened. Mr. Bobrod, do you have any questions? Any questions? So did the offender or the attorney have anything that you would like to state before we vote?
Thank you for giving me an opportunity. I'm not going to belabor you with reciting the law to you, and y'all certainly have the power to do whatever you want. I would just ask that you consider the fact that y'all, this is a first impression for y'all. It's on the affidavit, but the people who've seen and talked to the witnesses and listened to them have, including the judge not issuing a protective order, have basically fallen on the side of my client. And that does not bind you in any way, but I would just ask that you take that into account.
Ms. Stapleton, are you prepared to vote?
Let's go to executive session.
We have a request for executive session. Do we have a second?
Yes.
Without objection, we're going to discuss confidential information, and we'll be back.
Somebody in the chat called it and said they would go to executive session. But the good news is we're a few minutes on the Wayback Machine, so I can bump us past that. While I'm doing that, T celebrating 3 months with us as a channel member. Thank you, T, for all of your support. I appreciate you. Let's see here. Oh, it's a fairly long executive session. All right, here we go.
Francisco, you have to understand your past does influence and color decisions, okay? That's just a fact of life. We can't get around that. Today, my vote is going to be to continue you on supervision with some stipulations that you have to have a domestic violence prevention class on the outside, that you may not go to the residence where this incident occurred, that you're banned from that incident while you're on supervision. That's 2/2 of 30. You don't come back before then. So let's see what the rest of my colleagues have to say. Ms. Stapleton.
I agree with my colleague, Ms. Ledoux, everything she said. And the class, if available, that I would like to see you take is the 26-week Duluth class, which is very comprehensive on domestic violence. So, I mean, because there's a difference between anger management and domestic violence. And so if that's available, that's the class I would like to see you take.
And ma'am, it is available here.
Good. Okay, great.
And Mr. Barber.
All right, I'm gonna go ahead and concur with my colleagues, but I'm gonna add the anger management on top of that. Anger management class after the domestic violence class.
They are very different.
Yes.
You know, okay, that's enough said. So today, based on a unanimous vote, you will be continued on supervision with the stipulation, no, you're banned from the residence that happened, and that you take domestic abuse prevention and anger management. Thank you.
Alrighty, friends. Good morning once again. TCF Live on a Tuesday, now in hour number 3. Let's go back. Yeah, let's go back to Texas, Judge Stevens. While we wait for Judge Stevens to actually say something, reminder in the not in the blind sidebar.
Okay,
tonight.
26 CR 50.
Well, now you got to be quiet a second while I finish this sidebar. 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. Okie dokie.
And the state's attorney, you were charged with a felony of aggravated assault causing serious bodily injury by punching a girl in her mouth. And let's see, he received, according to the grand jury, permanent disfigurement and trauma to the bottom row of her teeth. You had punched her multiple times in the face and head and caused her to lose consciousness. If convicted of such a crime, you are looking at 20 years confinement in prison. Where is this lady now? Do you know? I'm asking you a question.
No, I don't know.
I find out you have any contact with her or anyone on your behalf, you'll sit in jail until this is over with. Because the court sees this often. Too often. The male punches out the female, and then some reason the female changes her willingness to prosecute because something is being done in the background improperly and illegally, people trying to contact the poor victim and make them feel worse than they already feel for being traumatized. This court doesn't think much of males who punch out the girls. It's not the way I grew up. And shame on anyone who does that. But two things happen. Either you punched her out or she just punched herself in the face until she lost consciousness and broke her teeth. Now, she's your wife, right?
Girlfriend.
Girlfriend. Okay. Well, who assaulted her if not you? I'm just.
No, I didn't know.
Oh, no. Well, didn't you go out and try to find out who did that to your girlfriend? I mean, isn't that important to you? You don't look at him. He didn't do it.
Judge, at this point, we're getting in.
I don't care what, he didn't have to answer. I can speak to him under the First Amendment all day long. But this court just does not tolerate people who mistreat others, especially people who have a legal relationship. You're supposed to protect the spouse, aren't you? No, that's what we learned, right? Well, I'm wondering who punched the poor lady out. Do you happen to help us with that? Don't you want to know? She's your wife.
Judge, he's announcing trial.
You don't care about finding out who might have done it?
Judge, he's announcing trial.
All right. All right. Is that right?
Judge,
or is he going to speak for him?
I'm going to speak for him, Judge.
Are you going to go for trial?
Yes.
All right. Where's the lady now?
I don't think he knows.
Y'all can't have any contact. That's a court order.
Okay. I understand.
Nor anyone on your behalf can contact him.
I understand that already.
You need something? Tom's looking.
No,
Oh.
Your Honor. So
No, you don't know. Does the state know where she is? I mean, she's still alive, isn't she?
She is. We have an address for her, Judge. That I'll remain.
But it's not
about it.
As far as you know, they're not cohabitating or contacting.
No, sir. And just to be real honest with the court, this is one I can prove with or without her. I don't know if the defense is thinking they can prevail because she doesn't cooperate.
The thing is about it, it just happens over and over again.
Yes, sir.
I find out that the people who have paramour type relationships in this often over and over again attempt to contact the victims, and that's just forbidden.
As I said, I can prove this without her. Her injuries are existent. The statements she made to medical treating folks are supportive. The admissions that he made, we're gonna, if they want the trial, we'll give it to him. He'll lose his opportunity for a deferred.
I mean, look, anybody, does anybody feel bad for someone, a female who ends up with permanent disfigurement from an assault?
I do, Judge, and that's why I'm going to try it with or without her.
It's not rhetorical. It's trying to make a point. This is serious. Set for trial, and there are no deals. Move this one. We're going to move this fast, please. This one we can get done. Vontae Frederick, John.
Well, John, this is at their place. Sweetie Son, I go to Discovery with this.
It's 2 years old.
I have not been on it for 2 years.
It's 2 years old.
I think this is only.
You didn't know it's been indicted? It was indicted in June of 26 of 24.
yes, sir. But I was arrested on the warrant.
I don't care.
Can I a different state?
2 years old.
I know, yeah. But I've only been on it a shorter period of time. So,
Well, you better get ready for us.
Yeah, I will.
All right. You're charged with a second-degree felony of burglary of habitation, which is too long, too old.
I know it's okay, Sierra, but it hasn't been, it hasn't been in this court at that long. I think he was in another state.
You're still at 6506?
Yes, sir.
Okay.
It was an outstanding warrant for a long time, Your Honor. Then you got arrested and started on the system, but it's an old indictment, but as far as in the court systems, we're relatively new.
It's an old indictment.
Old
The
indictment,
first
yeah.
time for somebody to show up 2 years after the event, it's already stale. And it's hard enough to make cases, put their things together after 2 years, but
Thank you.
He's got a fingerprint at the scene.
That's correct, Judge.
But he says he's never there. It was a miraculous or mystical event. So, for his fingerprint. What do we do now?
Just 4 weeks.
You got it?
Yeah.
Okay.
Get reset.
And Arturo Puente.
Right there.
What are we gonna do?
All right, this is also when we got an offer that should work out. We just need to go over some stuff. And I think it's our second time.
You're charged, sir, with the third-degree felony of evading arrest or detention, which carries with it up to 10 years in prison. And yeah, this one's about a year old too.
Yeah, that's.
Are you still at 2259? Why does this thing take so long?
I don't know. Last time we were here was our our first announcement.
All right.
Was
Four.
You got it.
Good. Thanks.
Stick around though. Give me a second. You've heard it.
Melzaneira Henderson.
Yeah, sure. It's gonna be, she's getting it printed right now.
Okay, tell me when you're ready. You ready?
She is, I think. That's what I'm saying. Yeah, I'm next. There you go.
Hmm? 26 CR 767 is now called is it Melzaneira? Melzaneira Henderson. Here with Mr. Dusler, your attorney and the state's attorney does. The defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes.
Okay. Harley Harrington, did you get a resetting?
If you don't know.
You can go. Yes, ma'am. Here.
Takes a while.
She didn't have the plea in her queue. Don, did you send it over?
Jimmy hasn't, he hasn't signed it yet. I think he just snapped up. It's working right.
In summary, and the defendant waives a formal reading of this, we can proceed.
Yes.
In summary, this indictment alleges that on or about January 11th, 2026 in Jefferson County, Texas, you committed this third-degree felony of collision involving serious bodily injury. Do you understand what you were charged with here, ma'am?
Yes.
If convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
In this case, an agreement has been reached.
Yes, sir. For deferred adjudication, no fine, but restitution to be determined.
The agreement has been reached between the parties. You would be pleading guilty, but not found guilty. You would be placed on what we call deferred or unadjudicated probation, so long as you follow the terms and conditions of probation, which are normal and customary for this type of offense. This can be up to 10 years in length. If you do well, it can be shortened to 1/3. If you fail, probation could be revoked and you could then be found guilty and then sentenced up to the full range of punishment. Do you understand what you're this?
Yes.
How do you plead to this? Guilty or not guilty?
Guilty.
Or pleading guilty voluntarily. That is on your own free will and because you are guilty.
Yes.
I'm going to show you what's marked here as states exhibit
Yeah.
1. Man.
Yes.
Okay, I'll show you what's marked as States Exhibit 1. Did you sign that document? Understand it, discuss it with your attorney, or the contents are true and correct. States Exhibit 1 tendered and without objection admitted.
Yeah.
Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the defense, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer and all true, so help you God. States Exhibit 1, part of the record for all purposes, pre-sentence report. Yes, I'm going to follow this agreement if nothing further. I'm going to find, Ms. Henderson, that you are mentally competent to enter your guilty plea, and it is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But this court is going to postpone or put off all finding of guilt so long as you follow the terms and conditions of probation. Where the probation officer is going to go over all of those with you, make sure you follow them. Again, as I said before, if you failed, then your probation could be revoked. You could then be found and sentenced. You don't want to foul up your record here. So do well. Also, there are going to be several terms and conditions of probation. Most of those are the kinds of things all of us have to do, like commit no crimes, avoid injurious habits, things like that. But in your case, we're going to order a defensive driving class to be taken and paid for by you. Although that is a win-win for you. And then you'll learn how to be more conscious about your driving. Your insurance will go down because of successfully taking this class. So it helps you financially. Yeah. This is for 10 years. And again, like I said, you do well. It can be shortened to a third, which is 3 1/3. And also restitution, we have TBD, to be determined. I'm going to, you are going to be responsible for any damage or loss to a victim caused by your wrongdoing, but we don't know how much that is. We're going to, probation office will look into it, figure it out, and we'll come back later. And, or I will sign a supplement. And you've got to help put those people back in the position they were before they were injured as best we can. You can't undo pain, but you can pay for, if it's your responsibility, you can't pay for the costs for their damage that was caused by your wrongdoing here. But that's how you fix mistakes. Make a mistake, then you fix it. You can move on and do better. Okay, please see the probation officer. Thank you.
It's TCF Live, bottom of the third hour now, half an hour to go. Let's get out of the South. We've been hanging here for a while. Let's go back up to Michigan, check back in with Judge McNally.
70608.
Good morning, Judge. Tom Graziani, on behalf of Denise York, who's studying the book.
Your name, ma'am?
Denise York.
All right, so this can be a plea to allowing an unlicensed driver to drive, right?
That's correct, Judge.
And then they're going to dismiss the suspend, true?
That's correct, sir.
Is that what you want to do, ma'am?
Yeah.
If you plead guilty to that added count, allowing an unlicensed driver to drive, possible penalties are up to 500 fines, 90 days jail. Costs are all those. It will not be reported to the Secretary of State. I'll dismiss the 2.93 drive while suspend misdemeanor, which is abstractable. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form today?
Judge, I explained it to her, but she did not.
Gotta have them sign these. It drives me crazy.
Judge,
Come on up here, ma'am. I want you to sign that advice of rights. Make sure you read it and understood it. Give me 1 second, Ms. Elway.
Okay, let me do it wrong. Yes, the day's day.
All right. Ma'am, did you go over those rights? Back up to the podium, please, with your lawyer today? Ma'am?
We discussed it today.
All right. Can you understand all your rights? Is that your signature at the bottom?
Yeah.
And you understand if you plead guilty, you're giving up all those rights and we're not going to have a trial of any kind?
Yes.
All right. Any questions before we go on?
No questions, Judge. I just want to indicate that she did obtain a driver's license.
Good. To the charge allowing unlicensed driver to drive, how do you plead?
Yeah.
On May 16 and 26 at 2:15 p.m., were you operating a motor vehicle, a Nissan on Elizabeth Park Drive, near Shelter D, I think it says, in the city of Trenton, County of Wayne?
Yes.
And you allowed somebody to drive that was unlicensed, and that was you, correct?
Yes, so.
Are you, pardon?
You said, well, someone, yeah. I didn't hear you.
Okay. You were driving the vehicle,
Right.
right? You knew you were suspended, right?
Right.
Are you on probation or parole?
No,
Anybody force you to plead guilty?
no.
Right, that plea to allowing an unlicensed driver to drive is accepted. The suspense dismissed. I'm ready for.
Judge, in this situation, Mrs. York had paid a good deal of money, approximately $400, and I'm asking what the court be as lenient as possible in assessing any funds.
Anything you want to say, ma'am? 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, $295 or 60 days. You can pay that now.
I pay some more money.
What do you mean? As opposed to what? You didn't think I wasn't going to fine you, did you?
I paid the $400. I paid like almost $400 before I even came.
Was it a bond, ma'am? Did you post?
She didn't post a bond. You know what she's talking about, Lisa? You must have paid the speeding ticket.
She paid her B ticket.
Judge, I'm asking for some time for Mrs. York to pay it.
How'd she pay $400?
Let me see. I don't think it was 400, but it was 135.
Sorry about that.
I'm sorry.
She'd indicated 400 to me. I was mistaken.
How much do you have today?
I haven't paid today.
When can you pay?
About 2-3 weeks.
Can you pay $75 a week?
I'll pay the whole thing in about 3 weeks.
All right. We think you can discipline yourself. I find that most can't.
You discipline yourself.
Yes.
August the 3rd. Pay by August the 3rd. August the 4th, 3 weeks from today. Okay? If you need more time, don't ignore me or else you're gonna end up having problems with your license again. Listen. You can
Judge, thank you so much.
Ma'am, if you don't have the money, call the court. We'll go on Zoom. I'll give you an
Probably before then. It's gonna get paid.
Okay, good luck.
Thank you.
Thank you, Judge.
Mohammed Hassan Mulhana, 26M700409. Where's Mr. Sala? Do I have Attorney Sala out
Yep.
there on?
Yeah, he's coming in right now.
Okay. Mr. Sala, you can start your video, state your name. I just called your case. Mohammed Hassan Muhana is 26M700409. Good morning. Your name?
Good morning to you and your staff, Your Honor. Hussein Salah, P72484, appearing on behalf of Mohammed Mohana.
All right. So this could be a plea to impeding. You negotiated this with the prosecutor. They're going to dismiss the limited access 5 over, correct?
That is correct, Your Honor.
To the charge and you're authorized to enter this plea on behalf of your client, true?
I am.
To the charge impeding traffic, responsible or not responsible?
Responsible, Your Honor.
All right. Once I'll accept the plea, dismiss the speed. 160 is the total. I'll give him until July 21. Okay, so he has a week.
Thank
Have
you,
a
Your
great
Honor.
day.
You
You
as
can
well.
tell him 33court.com. Okay.
Will do. Thank you.
Thank you. Susan Comendra. All right. Good morning, Mr. Clovis. Your appearance?
Your Honor, let me make sure. Am I muted? Let me see. Nope.
Bill Calovis, P 38434, on behalf of the defendant. Ma'am, would you please speak up and say your name?
Susan Kathleen Commandera, Your Honor.
All right, so what happened? Mr. Bresnahan wouldn't give you the deal?
No deal yet. No news is good news in this business, as you know, Judge.
Well, why is this taking him so long?
I don't know. What are you yelling at me for?
I'm not yelling at you. I'm asking why it's taking so long.
I don't know. I'll call
keeps
him and I'm not going to call him and say, hey, why are you taking so long? You know, he can make a real quick decision then and say no. So it's okay. It's going to be resolved. Fish or cut bait, as one judge says, next week.
10:45, July 21st. That's the preliminary exam. We'll proceed to the exam. Okay? No more
Judge, how
adjournments,
have you
though.
been?
If
How
you
was
get him
your
to do
week?
it, that's great. If he doesn't, well, I don't know what to tell you.
Gotcha. How was last
Yep.
week? Were you okay last week?
I had a great week.
Good. I'm
I had a
glad to
great
hear
week.
it.
I was off.
You know what my secretary says with the weekend or when you're off a day, it's like decompress.
Well, I'll tell you what, I was off. You know, we were closed on the 3rd.
Yeah.
And then we had the whole next week. I came back. I felt like I'd been gone a month, to tell you the truth. Maybe just because I played such horrible golf part of that time.
I heard you're a sharpshooter in the golf area.
Sharpshooter, all right. At croquet, maybe.
Anyway,
have a good day. Thank you.
Have a good day, Judge.
Ms. George, which one do you have?
Your Honor, I have Deborah Agrusa. We're waiving exam today, and she should be on shortly. She's just having a little bit of technological difficulty.
Okay, good enough. What's that, a preliminary exam or probable cause conference or what?
Today is a PCC, and we'll waive the exam.
I think this is the only case I've had not get adjourned.
I'm sorry.
It's all right. Morning, Mr. Davis. How are you?
Good morning, Judge. I'm well. How are you?
Not bad. Good.
I have SMP Express.
Okay, I don't think we have that file yet. I'm going to handle this other one. Hopefully they'll bring it in by the time I'm done.
Okay, sounds good.
All right, friends, let's looking about 20 minutes left. Let's go back down to Louisiana. New contestant at the board. We should be able to squeeze that in.
Handled at headquarters in Baton Rouge. On my left is Miss Carolyn Stapleton. To my right, Danny Barra. I'm Jerry Ledoux. We are at Vermilion Parish Jail. Is there a staff member there in the jail to introduce yourself?
Yes, ma'am. Ma'am?
Is there anyone in the room with you?
No, ma'am.
Okay. Would you introduce yourself, sir, with your name and your DOC number?
Tyler Kavon, bro. DLC number 730556.
Okay. Mr. Bro, you're before the panel with allegations that you have violated the conditions of your parole. Today, we also have Brandy Bonner, probation and parole agent. Ms. Bonner, thank you for your attendance. After we finish with the preliminary, then we'll ask your input. Mr. Barra, would you please continue?
All right. Looking at the preliminary hearing summary, you see that it's already been determined that you are not eligible for appointed counsel for this hearing. So we'll start with number one. You failed to report within 48 hours of release from good time supervision, which occurred on about February 22nd, 25. How do you plead to that violation?
Not guilty.
Okay. Number two, that you failed to report as previously instructed to the Abbeville office in the month of November of 2025. How do you plead to that one?
I plead guilty to that one.
During the month of February 2026, you failed to request permission to change your address of record with the supervising officer, and after moving from 2019 Graceland Avenue, Abbeville, Louisiana. How do you plead to that one?
Not guilty.
And number 4, that you have continued to engage in criminal conduct as evident by your arrest on 210 by Abbeville Police Department for committing the offense of possession of Schedule 1 marijuana, 109 grams, a felony, and that you pled guilty to amended charge of possession of marijuana under Vermilion Docket 73657 on or about May 4th, 2026, and was sentenced to 2 days parish jail with credit for time served. How do you plead to that one?
Guilty.
And as of the notice, you were arreared $756 in your parole fee account. How do you plead to that one?
I plead guilty.
All right, so we'll go back to number 1, where you pled not guilty, that you didn't report within 48 hours. What? Tell us why you're not guilty of that one.
Because when I signed out signed out my diminution of sentence, I was still incarcerated in River Bend, and they ain't transport me to Crowley jail until like 2 days later, which I bonded out of Crowley jail right then and there on the 24th of February.
And then when did you report in for your intake?
It says like 2 days later. 2-3 days later.
When you're talking about 3 days later, that's a violation. Supposed to be there within 48 hours. So it's a minor violation, but it appears to be a violation.
Yes, sir.
All right, and then number 3 is the second one you pled not guilty to. During the month of February 26th, you failed to request permission to move. Tell us, you said not guilty. Why are you not guilty of that one?
I wasn't technically done moving. Our lights were still on at the 2019 Graceland address, so everything wouldn't actually move into the house. Our address was still at 2019 Graceland. Like all our furniture was still up in there and everything.
Had you told your parole officer that you were getting ready to move?
No, sir.
Then you see how that could cause a problem?
Yes, sir.
So basically, what you're saying is you were moving, but you wasn't finished moving, but you hadn't told your parole officer about the move. You were gonna wait till you were finished moving, and then you would have called and told your parole officer that you had moved?
Yes, sir.
Okay, well, I'm gonna just read you the condition one more time. I'll live at the address on the parole certificate. If I must move from this address, I will get permission from the parole officer before doing so. So you see why the parole officer had a problem with that?
Yes, sir.
Yeah, because you didn't tell him before. That's the hang up. Again, not a coffin nail, but still a problem. You know, it's just another little one. You stacked up a bunch of little ones with one big one with it. And then on the rest of them you pled guilty to, so those we don't even really need to discuss those. But tell us why you shouldn't be revoked today. Why you think you shouldn't be revoked today? Because
I mean, honestly, I just have, you know what I'm saying? Like I have a lot going on, and I'm trying to better myself. And like, all right, I accept my fault, like in what I did wrong, like with the possession of marijuana. You know what I'm saying? I don't have a big drug problem. I asked Miss Brandy if she could allow me to go to rehab, which they have a rehab out here in Abbeville. It's called Wood Lake. It's like 30 to 45 days. She denied me. I don't know why. You know what I'm saying? I was just trying to better myself. I want to do better. I had I had 3 to 4 jobs when I was home. I worked at Ash Industries. I worked for a construction job in Youngsville. I also worked for Acadiana Bottling, and I also did mobile detailing work, like washing cars.
So you asked her to go to drug treatment?
I did. It's a program they got out here. It's in Abbeville, Louisiana. It's called Wood Lake.
So you have a drug problem that you're admitting to now?
Yes, sir. I mean, I don't have no major drug problem, but I do smoke weed.
There's no such thing as a major minor. If you got a problem, you got a problem. So you got a problem. But this isn't exactly what I see in the report from Ms. Bonner. Ms. Bonner, you seeing what I'm seeing?
Good morning, sir.
Preliminary hearing, it says that he was offered but refused. And then he's saying you refused. So can you clarify that a little bit?
Yes, sir. When Mr. Bro asked to go to the rehab treatment, it was after he had already been incarcerated and there had been a disposition on the charges. During that initial contact, he did admit to smoking marijuana throughout the duration of supervision. However, this case, I believe, had been reassigned to me, I believe, approximately 11 months ago, with the promotion of another officer here at the Lafayette District. So he didn't actually request to go to rehab treatment until he was incarcerated. And during that time, he said he didn't want to really spend any more time incarcerated on this and asked if he could go to drug treatment. When I explained that he was not eligible for a technical revocation, I mentioned the custodial treatment with DOC, and he denied having a serious drug issue. So he was presented with the option of the transitional work program. He wanted some time to speak with his family member about his options, and I told him that I would be back the next day. However, the following day, whenever I came in, he was very argumentative. He refused the transitional work program and said that he would rather just gamble with his parole board hearing.
Do you have any recommendations?
I do believe that there is some issues with him taking accountability for his actions. And I've said with most of my cases throughout my career that you're free to decide on parole with whatever choice you want to make, but you're not free from the consequences, whether they are good consequences or bad consequences. I do believe that he does need drug treatment. I believe that he does need it in DOC custody. However, if the parole board feels that that's not necessary, at least he could be in the transitional work program.
Thank you. Anybody else
Yes,
have
sir.
any questions?
I want to probe a little, not from his phone. Thank you very much. I do want to probe Mr. Bro a little bit more. Okay. So you wanted to go to rehab, get out of jail as an alternative to being in jail. Like, okay, I'll go to this drug rehab, but I don't want to be in jail. I've heard you say you don't have a big problem with drugs. So smoking marijuana is a way of life for you, right?
Yes, ma'am.
What other drugs do you use?
I ain't never used no other drug in my life but marijuana.
Okay. One time I asked someone if they had a drug problem, they said, no, y'all have a problem with my drugs. I don't have a problem with drugs. I think that's probably where we are today. Lack of cooperation with your parole officer. You're a fourth felony offender. How many times have you been on supervision?
How many times like I've been on supervised parole?
Or probation or parole?
I've been on probation one time, and this is my first time on parole.
Okay. So maybe you don't understand how serious it is. Okay. I have Mr. Bob Rod prepared for you.
One second.
Oh, sorry.
Sorry. I did want to just clarify, periods of supervision. Mr. Bro actually has been on supervision more than just twice. He's had a few split sentences. He's had a probation. He's had 1, 2 probation, 3 probations, and then I believe 1, 2, 3 terms of supervision that have been on parole.
I don't.
Just wanted to clarify that.
Yeah. Those ended revocation, any of them ended revocation?
If you give me one moment, I'll be able to tell you, ma'am. Let's see. Previous period of supervision. He stipulated to probation revocation hearing on November 1st, 2018. Let's see. He violated his probation and revoked probation in 2024. The parole board terminated his parole unsatisfactorily in February of 2025 due to he would owe no time if he was revoked. Let's see. This one. This one was a successful completion in 2019. And the last one that I have was he was revoked January 14th of 2019. And that was a probation case. So he has had several periods of supervision.
Thank you.
Yes, ma'am.
All right. Taking into consideration the offender's request and the probation officer's recommendation, I'm going to go ahead and not revoke you today, order you to go to long-term DOC treatment.
Yes, sir.
And I concur with my colleague.
I would revoke you and send you in lieu of revocation to long-term substance abuse. So you're saying.
Well, that's what
Wait,
in lieu of revocation.
I thought you said continuing. Okay.
What if I said that?
In lieu of revocation. In other words, you are going to remain in the custody of DOC and go to a long-term substance abuse program. That would be my vote as well. So unanimous vote. You are in lieu of revocation going to a long-term substance abuse program. And that concludes our business there with Vermillion.
Alrighty, friends, we're going to call it a morning here in just a second, but before we do that, I wanted to quick flip over to Judge Stevens' court, where, good for them, they're having movie time this morning. You can see the flicker inside the courtroom just like it's a real movie theater, and I think that's just super cool. So, good for them. I hope somebody brought the popcorn. It doesn't look like they've broken it out yet, but hopefully they will soon. Okie dokie, friends. We call it a morning here, but we will be back tonight for Sidebar. 8 p.m. Eastern, 5 p.m. Pacific. We're going to be discussing that crazy case that we saw in Judge Stevens' courtroom last week, where basically it was an incredible comedy of errors. Basically everybody who had a role there did something wrong, it would seem. So we're going to discuss that tonight. This stream will redirect over there when it's done, so you can set your reminders. And if you're not familiar with the case, there's a link to it in the description for that show, so you can go back and watch it. But again, we will see you tonight, and I look forward to seeing you all tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, half an hour earlier if you're a channel member. Today's wisdom comes from Norman Vincent Peale. He says, forget mistakes, forget failures, forget everything except what you are going to do right now, and do it. There you are, my friends. Have a good day. We will see you soon. Take care. God bless.